Is that a legal job?
No.
Okay. That's very mild. Good. What is the name of the lady with the she's going to be
Just want to make sure you have this. We had a person that had applied for standing that wanted to be taken off the list and they emailed us.
Okay.
So just want to make sure we had that information.
Thank you.
Good morning, everyone. Let's call this meeting of the Cashiers Area Community Planning Council to order. It seems that we have 6 of our members here, so that's a quorum. Does anyone have any additions to the agenda today that we've been presented? If not, if I could have a motion to approve the agenda as presented. I got a first from Bob and then a
Are we getting delayed feedback from YouTube?
excuse me?
We're getting the delayed feedback from YouTube. We need to stop that because you're just going to hear repeated back everything you're saying.
Okay.
You need to be on the Zoom screen and not the YouTube.
Let me know when that's done, please. All right. With that being said, if everyone has had a chance to approve the minutes from our December 14th meeting, I'd like a motion to approve those if there are no changes. Dave makes a motion to approve. Seconded. All in favor? All right. Okay. With that said, we'll move back on to item number 4A, the special use permit for Cashiers Village. And we will reopen the hearing. But before we do that, I'm just going to read some general information, and I'm going to have Heather Baker make a brief presentation on North Carolina's thoughts on standing. So generally, a quasi-judicial hearing is an evidentiary hearing where the Cashiers Area Planning Council will make a decision based solely on competent material and substantial evidence in the record. The record is all of the materials and input that is presented to the council, including the application, exhibits, testimony, and related materials. The record may include some insufficient evidence, but the council may not base its decision on it. The procedures provided here are not meant to be binding rules, but to be a flexible guidance for the conduct of the hearing. Witnesses shall avoid hearsay evidence. Hearsay evidence is testimony that the witness does not know of his or own personal knowledge, including that which someone else told the witness. Unless they are a qualified expert, the witnesses are not competent to testify about the impact of a proposed land use on the value of other property, the danger to public safety resulting from increases in traffic and other matters that require special training or expertise. The chairman of the Cashiers Area Planning Council may rule on any objection or request from participants regarding the procedure of the hearing or the evidence presented with or without objection. The applicant has the burden of producing competent material and substantial evidence for the Cashiers Area Planning Council to conclude that the standards of the application ordinance have been met. If the applicant shows that they meet these standards, then the applicant is entitled to approval unless those opposed present competent material and substantial evidence that one or more of the standards have not been met. So just for everyone's information today, we will not get into the full hearing today. We will focus on judging those that have applied, whether or not they have standing to be parties to this action. And what I've heard is that this should take till about 1 o'clock at the latest, at which point we will adjourn, if it is acceptable to the council, to the 25th, and probably move that to a morning meeting for the main part of the hearing. So with that all being said, Heather, if you could come make a brief presentation to the council on standing.
Good morning. I'm going to do this from here, so I think the mics are will work for both the online and those here in the room. So a party with standing, we've had this conversation several times over the years with your hearings. Typically, you don't have many parties applying with standing to come before you. And so you've taken a kind of lenient position that if a person received a letter from the planning department saying that a hearing was going to happen and they're an adjacent property owner, you've pretty well let them into the hearing as a party with standing, because we may have some objections to parties that have applied with standing today. Going to need to be a little more formal in your decision making with regard to parties with standing, but this information is the same as what we've always presented to you, and that is a party with standing is an aggrieved party. And I'm going to go over the short list of those who have standing. Relatively few people actually have standing in a quasi-judicial hearing because of the things you have to show to be able to do that. One is a person who has legal interest in the property owner, a tenant, something of that nature. The applicant has standing. The county where the council is being heard, Jackson County, has standing. A person who will suffer special damages as a result of the decision. And that's what I'll talk a little bit more in just a minute. And finally, an association connected or associated with it that would have at least one member of the association that would have standing. So typically that's going to be an adjoining association. You may hear some about that this morning. So about a party that has special damages. We are required, the county is required to notice all of the adjacent property owners. That does not mean they automatically have standing. That is one factor. One factor is proximity, how close they are to the property. Also, will they have an effect on their property value? If they allege that, they have to be able to show that that could be the case. And finally, that they've suffered some type of may suffer some type of secondary damage. That can be noise pollution, lighting, a traffic problem specific to their property, not the community as a whole. And one of the best ways to look at a party with standing is to say, is this person's potential damages different from someone in the community as a whole? If anyone in the Cashiers area can say, yeah, I could say the same thing, it's probably not special damages. Whereas if this person can say, my driveway will intersect, I will personally not be able to get out of my driveway, or I will have light directly on me, or noise, those are your secondary damages that you can look at in considering this. So we do have a lot of applications this morning before you. I want to introduce two attorneys. Craig Justice, who's the attorney for the applicant, is here, and John Noor, who represents several parties who have applied to have standing. And I think you'll hear a little bit more from them this morning about standing and moving forward. And I'm here to answer any questions you have and guide you through this as we move forward. Any questions that you have right now with regard to standing?
Heather, if you just could briefly tell us how the procedure of how initially these attorneys and then those parties that are unrepresented, how are we going to hear their arguments?
Well, what I would recommend, and again, it's up to you. You determine how this hearing moves forward. But what I would recommend is that you start with Attorney John Noor's clients. He has reached some stipulations with the applicant's attorney about some of his clients, and he'll go over that with you. That is allowed. That is something that they can do. It's made, their discussions on that were made to streamline this process this morning. I still think it's good for them to present some of the evidence and to show to you why they feel that their parties have standing. So for all of those coming after, we'll also understand what they need to present. And then once he finishes, I think he's going to ask that you wait and vote on all of his clients at one time. And then once that's done, if you want to go through that list, the Excel list that you have with each party that's applied, give them the same opportunity to present their evidence. And then you need to make a determination one at a time, because each of these is a different special case that you'll vote on whether or not that party has standing moving forward until we've gone through all of them.
Okay. Thank you very much, Heather. So if I have not, let me now resume the hearing. And with that, Attorney Nora, I'll throw it to you, sir.
Good morning, council members. As Heather pointed out, I represent 5 different parties that have applied for standing in this application process. Ms. Yvonne Johnson, Laura Moser, Jeannie Mingy, the Chattooga Conservancy, and the Johannesson Property Owners Association. So if you have that little checklist in front of you, those are the folks that I represent. Mr. Justice and myself, who Mr. Justice represents the developer, we have reached a stipulation, which means an agreement that 4 of my 5 clients have standing. And what we've agreed to do in consultation with Ms. Baker is to talk about Ms. Johnson's application and affidavit that she submitted to you all, just so that essentially the public has an example of what's going to happen next when we get to their applications. But we have agreed amongst the parties, stipulated that Ms. Johnson, Ms. Moser, Ms. Mingy, and the Chattooga Conservancy have standing in this case. And so the reason we do that is it also speeds it up so that we don't spend the same time talking about the same issues for all of those parties in front of you, so that you can get to some of the other folks who've submitted applications. And so at this point, I guess I would just ask Craig to confirm that, if he would.
Craig.
Thank you, Mr. Chairman, members of the board. Yes, John stated correctly. Mainly to expedite matters, we've agreed to this stipulation as to the 4 parties that he mentioned.
And so at this point, I'd ask if Ms. Johnson could be allowed access. I'll go through her application and ask her some questions about that. And then at that point, I think we'll turn it back to the board and ask for you all to essentially accept our stipulation on those 4 parties that I mentioned. And then we'll move on to the Johannesson Property Owners Association, and you can review their application and determine whether they have standing. And from there, then I think Heather will direct you on to the other parties who have applied. And I'm happy to answer any questions board members might have about the process, and if that's acceptable to you all. I'm seeing nodding heads, so I'll take that as
I believe that's acceptable. Just proceed.
Okay. Ms. Johnson, can you hear me?
Yes, I do, John.
Good morning. How are you today?
I'm good. How are you?
I'm doing all right. So could you introduce yourself to the board? Give your full name, please.
Yes, I am Yvonne Johnson.
And Ms. Johnson, where do you live in
I
Cashiers?
live at 71 Bustle Lane.
Could you say that one more time? I had a hard time hearing that.
71 Bustle Lane.
Okay. And where is that property in relationship to the proposed development?
My property is abutting the proposed development, and I am downgrade from the ridge.
Okay. And did you receive a notice from the county related to this hearing as an abutting property owner?
Yes, I did.
Okay. And when you say you're down ridge, when you say that, do you mean that your property and home is situated below buildings and structures that are proposed in the development?
Yes, my property is directly below the proposed 5 multifamily use buildings. And when I go outside of my house and look up, I am looking at a very steep incline, which is on the order of 70%.
Okay. And when you say 70%, you're meaning the grade in that area?
The grade is very steep, yes.
Okay. And did you submit an application and affidavit in support of standing in this case?
Yes, I did.
And that affidavit that you submitted, all of that is a sworn statement on your part about the basis for your standing, correct?
That is correct.
And on page, I guess it's 2 of that affidavit, what is the green star there indicate, is that representative of your property in relationship to the proposed development?
Yes.
Okay. When you access your property, what major public road do you use to do that?
The only road I can use is 107. Bustle Lane comes directly off of 107. And Bustle Lane serves as the entrance to my home and 4 other properties.
And that's your only access to your property, correct?
The only access.
Okay, so if there was an issue with traffic congestion on 107, that impacts your property because of the fact that you exclusively use that road to access your home, correct?
That is correct.
Okay. Now, in your affidavit, you reference a few different areas of damages that you are concerned about or that you allege you would suffer as a result of the development. The first one is traffic congestion. I think that's paragraph 6 in the affidavit. Can you talk to us about why you believe you're going to suffer traffic congestion and traffic hazards as a result of that development?
Well, as I said, the only way I can get to my home is from 107. And currently in the high season, it's very difficult to turn left safely. And so the way I have to access South 107 is to turn right and go north and make a U-turn and go south. And I go to the Good Shepherd Church and the Refuge Center, et cetera. I'm concerned about traffic congestion with the proposed development because already we have a lot of congestion and this will serve as an increased congestion. I am concerned that given that situation and with the only way you can get to my house is by 107, that emergency vehicles might be prohibited from reaching my house as needed.
Do you regularly experience delays in accessing 107 during the high season?
Yes, I do. Oftentimes I'm trying to turn out onto 107. There is backed up traffic from Frank Allen Road.
Okay. And another area that you mentioned in your affidavit is landslide risk. Can you talk to or tell the council why you are concerned about landslide risks as a result of the development?
Well, the proposed 5 buildings behind my house are multifamily houses, so large, and they are on the steep incline. And so I do believe that that type of topography is wrong for those types of buildings. And I'm afraid of a landslide down onto my property. And furthermore, the properties directly below me.
And does that make you, again, talking about the uniqueness or the differentiation between your property and others in the community, others aren't similarly situated to you, correct?
That's correct.
It's because you are directly below those buildings on a very steep slope that make your damages unique.
That's correct.
Okay. And not going into the substance of it, have you, again, I'll emphasize, don't go into the substance of any opinion you've obtained, but have you consulted with individuals in that field of engineering to confirm your, or to corroborate your concerns?
Yes, I have.
And let's not go into the, Yvonne, let's not go into the substance of it. I just want to get before the board that you have talked with someone about that and have an understanding that that's an accurate concern.
I have.
At least in your opinion.
Yes.
And then you also mention in your affidavit concerns about sedimentation and stormwater damages. Can you talk to the council about why you believe that would occur on your property?
Well, the proposed development behind my house includes parking spaces, which would be impervious surfaces, and the stormwater would have to be routed in such a way as to prevent, say, landslides. And I'm concerned about the water runoff and the damages it could cause.
And is that because you're going to, what's the current condition of that property behind you? Is it wooded or is it developed or what?
It's wooded. It's wooded.
So instead we would have buildings in that area and impervious surfaces, correct?
That's correct.
And your concern for stormwater is that that's going to channelize stormwater in a way that would come across your property and do damage to it, correct?
That's correct.
Okay. And I think those are the questions that I'd like to ask you, just to kind of hit the highlights of the unique damages. And at this point, I'd ask the board if they have any questions for Ms. Johnson. And maybe now's the time that if we can stipulate to Ms. Johnson, Ms. Moser, Ms. Mengi, and the Chattooga Conservancy, we can wrap all of those up together and then move on to Ganasita.
Do you have any proof that the grade above her house is 70%? That seems like a real high claim.
So one of the things that Ms. Baker can clarify for the council is that at this stage in the proceedings, what an applicant for standing has to do is allege the damages. That is, they're saying, I've looked at this and I believe these are the problems that are going to affect my property. At the next hearing, we will get into the substance of the case, which is, now I've got to prove for you what I alleged. So if I said I had traffic congestion and I had landslide risks and I had stormwater issues, here's the proof of that for the board. And so today is just about us alleging it and not proving it, just to make sure that the right people get in the door to represent their interests before the commission. And the next meeting will be about that proof. And if Ms. Baker has any, disagreement with that,
Would you agree with that, Heather?
So we do have a legal difference of opinion as to, for standing, whether or not you have to prove in addition to allege. I will say that a number of the statements that Ms. Johnson made appear to be without grounding in fact. Statements about traffic, as you probably have been coached, requires a traffic expert. Statements about impacts from the property in such a way about sedimentation, stormwater, again, those things we'll have experts. So she is making allegation of concerns. I will agree with that. But we were looking to expedite this process to identify her uniqueness as being an abutting property owner who happened to be below the project. And those were things that presented her uniqueness in a way for us to go ahead and expedite her being a party.
Understood. Okay.
So,
Excuse me. So at this time, the two parties have agreed that to expedite things, that they've agreed that these four people have standing. So at this time, the council could vote on those four parties having standing. Is that correct, Heather?
That is correct. And moving forward, I just would want to say, yes, I agree with Mr. Justice's opinion at that point, that it does take something more than just allegations at this point, but they have stipulated so that they do not have to get in to the weeds of experts that they may have ready and available, and they'll wait and do that next time. But for purposes of those coming up, it does take something more than alleging. However, as Mr. Justice also states, I think you're looking at, has she shown uniqueness, special damages to her particular property versus someone in Cashiers as a whole, and I think you probably have that in front of you. So yes.
Understood. That was helpful. Thank you very much. So at this time, if the council members would like to, can we vote on all four as a group?
Yes.
Okay, so all those in favor of agreeing that these four parties, that the two parties have agreed have standing in this action, please vote at this time. Yes. All right, all in unanimous. So moving on, now we will hear Mr. John Knorr present the case for Paul Lee Anderson and the Ganasita Property Owners Association.
Just give me a second, Your Honor, while I pull up those materials. I think,
Mr. Chairman, as part of the stipulation and in the effort to expedite was to take John Knorr's clients and agree on those that have standing and essentially not get into the remainder, which happens to be the two that you just mentioned.
I think, yeah, Ganasita, the affidavit is before the council, and we're not going to offer anything in addition to that, and you all just resolve that however you would wish. I'm not going to offer anything in addition to that. We don't want to be heard on that for that party.
Okay. So does anyone, Heather?
Do you have the affidavit with you?
For Paul Anderson and Ganasita?
Yeah.
I do. Those were the ones submitted in November as well.
Okay. We need. Yes, Alton. Okay.
Yeah, we have
Give
them.
everybody a minute to find them.
So, Mr. Chairman, it is a little bit different as this is developing. We agreed that we would make a statement that even though they don't necessarily are not being presented for standing, that they can still participate through John Noor and exercise all the rights of standing without us labeling them with standing, so that we could move on to the non-John Noor represented parties.
We're comfortable with that. I mean, I think the understanding would be they could testify like any witness might be called in this and participate in the hearing, which is permissible, but they would not have the label as a party with standing. If Ms. Baker is.
So,
I will leave that up to the council, and I'm sorry, I got talking to this thing. I'm going to leave that up to the council. We typically have not had a section for witnesses per se, non-parties with standing who are allowed some to participate, but are not considered a party with standing. You can do that. It is up to the council if you want to do that. And if you do, they would not be a party with standing, but would participate through Mr. Noor, I would presume, in the hearing, be able to ask questions through him or offer testimony if called upon.
And that's correct. And I think what we'd offer is that would be the motion the council would vote on, is that Ganasita, isn't decided to have standing, but can participate in the hearing as though they did. And unless Mr.
correct, because John Noor is already present, already presenting witnesses, so it's somewhat duplicative. So just again, to expedite this morning, we agreed that the association and Mr. Anderson would essentially step back, and that now you would move on to the non-John Noor represented parties. So that
well, if both parties that are represented agree to that, I mean, it's a little unusual, but I don't see that it's a big problem. I mean, they're going to be represented in the questions and comments of witnesses called by Attorney John Noor anyway. So at this time, if the council would like to vote to approve the Ganasita Property Owners Association participating, but not as a party with standing, as agreed by the two parties represented by council, at this time, please vote yes.
Or if you want to have someone make a motion to that effect, because for the minutes, for the record, you're going to need a motion, a second, and then a vote.
Okay, if someone would please make that motion. As a participating party without standing. All right, can I get a second? All in favor? Aye. Okay. So I believe that brings us to the end of the parties that are represented by Mr. John Noor. And so then we will begin with those folks listed on our list that are not represented by, and I'm just going to go from the top to the bottom of this list. It seems that the first are Deborah and Stephen Clark. So if we could get them speaking on the Zoom call, and at the same time, if members of the council could find their permit, that would be, their application, whatever it's called.
Yes, we're this is Steve Clark. Debbie, are you on the line?
I'm here as well.
Okay. Now, Heather, in the previous case, obviously, John was asking the questions. Are we to ask questions of these people? Are they to present their case? How do you see this going?
Yes, you can ask questions. I can ask questions. Either attorney can ask questions. Any party that's been determined to have standing can ask questions. At this point, they're all John Noor's clients. One thing to keep in mind is that You do have to show, if you do determine that someone has standing, we have to have a finding as to special damages. For what's been done so far, you can leave that to staff based on the information that was presented to show in the record what that finding is. But for each one coming forward, if you vote that they have standing, make sure that includes some reference to what their special damage is, so we can include that in the record.
Okay, but staff has not made an individual determination on these.
No, that is up to the council.
Yeah. Okay, so do I have a separate application from Stephen, or is it just this one that says Deborah Lenz Clark? This.
They're both
In
the
the-
same.
In the
Okay,
interest
I
of
have them here.
time, you can let Steve speak for both of us.
Okay, Steve, having
Yes.
heard what we reviewed so far on standing today, do you still allege that you have standing?
I do, because I have proximity. I am not adjacent to the property, but I am within a very short distance from it, and I have a negative impact from it.
Okay. Have you what damage will you suffer?
Primarily traffic increase. We exit on Pilgrim Road right near the intersection of 107 and 64, and the increase in traffic would be substantial, especially in high time.
Have you contacted any experts such as a traffic engineer to establish this?
I have not.
Okay.
Also made a claim for.
Please speak into the mic, Bob.
Hi, Steve. This is Bob Dews. You also have alleged that your water or your well might go dry or deteriorate in quality. Do you have any thing to officiate that?
Not at this point, no.
Okay.
Okay, so, you know, even being an adjoining property owner is not sufficient grounds to immediately establish standing based on what I've seen reviewed. So it seems that, to me, that you guys are reaching a little bit to establish standing on this. Because you don't have any specific evidence to say that this would happen. You're not immediately adjoining it. Before I call for a vote, is there any other comments or arguments you'd like to make?
By me?
Excuse me?
Are you asking me, or are you asking other parties in the room?
I'm speaking to you, Mr. Clark.
Okay. I understand that I do not have adjoining property issues. My main concern, as I said before, was the potential for a depletion of water table levels and the increase in traffic based on the proposed project would be substantially affect my property and potentially my property value.
All right. So just reminding the council, we have to have, like, our standard that, as I understand it, is that we have to have, a credible allegation of harm. It has to be supported with fact in some way. Their standing has to be established as higher than the general public. While I understand Mr. Clark's concerns, it seems to me that it's very similar to the concerns of the general public. So at this time, I would ask for someone in the council to make a motion to either.
Before making a motion, Michael, I think we need to hear from the other parties if they have any questions or anything to contribute
Okay.
with regard to this one.
Thank you. Are any of the other parties that to this action, would you like to make any objections or comments?
Oh,
Can't hear you.
so can everybody hear me?
Steve, are you able to hear?
No.
am now, yes.
All
This is the attorney, Craig Justice, the attorney for the applicant who's about to speak.
Hi, Craig.
First off, I just want to be clear that we're not throwing a blind eye or blind ear to deaf ear to concerns. We want to have this process to be one of transparency, to answer any questions anyone might have, so that this gentleman and his wife can participate by asking questions, so that we're fully transparent, so we can deal with the concerns that have been raised. But for purposes of standing, it is a very narrow principle of law where our judicial system has decided, and our General Assembly by statute has decided, that not everybody in the world gets to come in and be a quote unquote party. And as you heard from your Heather, special damages there are two components to it. One, there has to be some sort of damage, and generally that is evidence of a property value decline that only can be presented through an expert. And then you have to be special, meaning it has to be uniquely affecting you. And oftentimes you'll need an expert to show that, in terms of showing stormwater that would be real, not fanciful, not speculative, but actually real, that would affect you uniquely. So you have uniqueness and you have damages that generally require some sort of proof of property value decline. So respectfully with this gentleman, he hasn't presented evidence of either. But we
As a
still want
counter
to hear
to
the
that,
concerns.
as a counter to that, I can employ those experts to counter your argument. That is not, at this point, I'm looking at whether I have standing. As far as an argument of damages, I would have to get those experts, and I am willing to do that.
Heather, what are your thoughts on that?
What Mr. Jess is saying again is correct. It's today, as they've applied for standing, what can they present? What can they prove with regard to standing? I think it is good that the attorneys involved and the parties so far involved have no objection to somebody who's determined not to have standing still participating as a witness. They'll still get to ask questions. They're just not deemed a party with standing because they didn't come in today with that evidence to be able to present to you to show that they have standing. And that is a good way to move forward. And no, it's not something this council has done, because typically we don't have hearings of this size, of this nature. It is done in other areas where they do on a more regular basis have hearings of this size. So it's not unusual per se, it's just unusual for us because we don't have these types of hearings.
So if we were to prove them in that fashion, when you say they're going to be able to participate as a witness, but not a party, they wouldn't be able to object. When would they give their testimony?
During the hearing, like after all of the parties do, they would be able to also ask questions. Once the applicant is able to ask questions, once the council asks questions, once Mr. Noor asks questions, they would have an opportunity to ask questions. And then once all testimony has been given, they would have a chance to then present to testify as well, probably just on behalf of themselves. Could have a time limit, as we've talked about before, or the council could decide how they want to hear that evidence, but it would fall in line after the applicant and other parties that do have standing have given their evidence.
Steve, would you have a problem participating in the hearing in that manner that Heather Baker
witness?
just described?
I'm okay with that.
I do have just a couple questions for the record before the.
Please go ahead, Attorney Noor.
Mr. Clark, this is
Yes.
John Noor. Good morning.
Good morning, John.
I wanted to ask, is your property on well water, correct?
Yes, it is.
Okay, and approximately how far away from the proposed development is your property?
Third of a mile.
Third of a mile, okay. And are you familiar with a water study report that was done for the Tawassa Sewer Authority back in 2018 related to water availability on the Cashiers Plateau?
No, sir, but I would like to see that.
Okay. Those are all the questions that I have.
Thank you. All right. So at this time, if I could have a member of the council make a motion to allow Steve and Deborah to participate, but not as a party withstanding. If I could have that motion at this time.
So moved.
All right, Bob's making that motion. Do I have someone seconding it? All right, it's seconded by Robin. All in favor? Aye. Okay. Thank you very much, Steve.
Thank you very much.
All right. Moving on to Anita Kramer, if we could find her application. She's listed as being here in person? She's not here? So she will not. Is she here virtually?
I can share a little information about Ms. Kramer that might be helpful for the council to be aware of. She's not my client, but I will let her know that I was made aware that her husband's in the ICU.
Ugh.
And so it may be an issue that she is tending to a family member today. That I'll just throw that out for the council's consideration, that maybe this is somebody you consider on the 26th, considering her circumstances.
Say that again?
Maybe this is something you consider on the 25th or the 26th at your next meeting, considering her health circumstances. But I received a text from her last night representing her husband was in the intensive care unit and that she may not be able to participate today.
Okay.
She is not my client, for clarity.
You could choose to wait and hear hers on the 25th if that's the case, or you could look at her application and see if you can make a decision based on her application that is before you.
How do the other members of the council feel? Would you like to just wait and just handle this first thing on the morning of the 25th?
Yeah, she's an adjoining property owner. So
Yeah.
therefore, I think she's got a pretty good reason to maybe qualify for standing.
All right, well, let's just wait till we can hear from her and we'll handle that first thing. If y'all could remind me that that's the first thing we're gonna handle. All right, moving on then, the next gentleman on my list is Sean Cronin. Sean, are you on the Zoom call? So in Sean's application, he is not an adjoiner. He lives at 53 Honeybee Bend, which is not close. And he is not alleging that he will suffer special damages, but would like to be heard by the council. Would either of the attorneys for the council object to him being admitted in much the same way we admitted the Clarks?
Mr. Chairman, I do not. I do want to be clear that the statute, so the General Assembly creating the statute, does recognize that non-party witnesses can still testify. They're held to the same standard like any other witness, that they must present competent material, substantial evidence as part of their testimony. So although I have no problem, full transparency, this gentleman being able to ask questions, I just want to caveat that if he wants to testify, he still has to funnel it through comments that are relevant, material, substantial, competent stuff.
Yeah.
So with that caveat, I have no problem with him asking questions, like we have no problem with anybody in this community asking questions.
Yeah.
We have
Attorney
no objection to that.
All right. I don't have a problem with this gentleman. I don't know him participating. I don't think. I might know him thinking about it. But at the same time, I think Honeybee Bend is in Trillium. These are the kind of people that, while they're a member of the community, and I'm glad they want to participate, all for keeping this orderly and simple, I don't mind having these people participate as witnesses. I'd also not mind not having them participate as witnesses. Are there any thoughts from any other members of the council before we make a motion?
We're quick. Mr. Chairman, it appears as though we're probably going to have a lot of the applications here that have a common theme, whether it's traffic. We've already learned that these people access their residence on Highway 107 or Highway 64. Well, we all access our property off of Highway 107 or 64 eventually. So traffic is a common theme. We don't have any, unless somebody has some substantial evidence by a qualified candidate that can verify their testimony. The other issue that we're going to have is water availability. And as the Clarks testified, as I think all of us can testify, we're all on well water here because there is no municipal water source. So once again, it's not unique to an individual. It's a common theme in Cashiers. Maybe to expedite this, if there's others in here that are saying, I'm going to have trouble getting out on 107 or 64, and I'm going to have trouble with water, unless it's verified, can we just get beyond that?
I think we really have to go person by person if they've made this application, but I think that's a good point, and we can look at those points quickly and move on. But I think if we set a little bit of a precedent, like someone like this who doesn't even live in the area that, or within a quarter to a third of a mile of this, that we appreciate his interest. But I think 53 Honeybee Bends in Trillium. You're Mr. Trillium. So, so it seems like the sentiment is maybe that we appreciate this gentleman's interest, but that we ask that that we will vote that he is not a party withstanding and he won't be participating as a witness. Okay, so if someone could make that motion, please. And it will not participate as a witness. All right, Dave makes that motion. Do I have a second? All right, I have a second. All in favor? All right. All right, moving on to the application of Mary M. Ellis. Is Miss Ellis on the Zoom call?
Yes, can you hear me?
Yes, ma'am.
Okay, our family has property on Monte Vista Road. It is not adjacent. I would say it's within a quarter mile of the proposed development. Our biggest concern is we're on private well. In fact, during a period of drought, we even had to drill a second well, which subsequently went dry. So water availability is a big concern. Traffic on Monte Vista Road is another big concern. I am not represented by Mr. Knorr. I've contributed to the legal fund, but I'm not one of his clients. And I would be happy just to participate as a witness.
Okay. With that being said, are there any questions from either of the two parties that are represented by council? Comments? No.
I have just a couple, if I could, with Ms.
Please,
Ellis.
Mr. Knorr.
Ms. Ellis, you'd mentioned, so you've already experienced water availability problems on your property under current conditions, correct?
Yes, we have had this property since 1897. And although, there's usually a lot of rain, you also experience periods of extended drought in Cashiers. And I'm not sure that this developer is recognizing that. And yes, we have had trouble getting water.
And you had to drill a second well already as a result of that, correct? And in relationship to the property, how far away from it are you?
I would guess a quarter of a mile, as the crow flies. Okay. We're at the end of Monte Vista Road, sort of up on.
And as I asked I think Mr. Clark, are you familiar with the report that was the engineering report that was put together for the Tuckasegee Water and Sewer Authority related to water availability back in 2018?
That, and I would be very interested in that.
Those are my questions. Thank you.
Thank you. At this time, if I could have a motion from a member of the council that she is happy to participate not as a member with standing, but only as a witness. my instinct is that we allow this considering her circumstances. If I could have a motion to that effect. Okay, I have a motion. Do I have a second?
I'll second.
And who made the second? Robin. Okay, all in favor? Aye. Okay, it's unanimous. Moving on to a Mr. Robert Goodman of Wade Hampton is what it's listed here. Robert, are you on the Zoom call? Okay. Looking over Mr. Goodman's application here, he did not receive a letter from Jackson County. He is not claiming to suffer special damages. My instinct is that we just do not allow him as a party with standing. And he is not on the Zoom call.
Mr. Chairman, I'd like to admit that Robert Goodman is not qualified as a member of standing.
Okay, do I have a second?
I'll second.
Okay, second by Robin. All in favor?
Aye.
Aye. Okay. Moving on next to Mr. William Wallet and Susan Graham. Are they on the Zoom call today? No? Didn't want to come talk to us? So in Mr. William Wallet and Miss Susan Graham's thing, they do not claim, they do not fill out whether they received a letter, but they have attached this document. Looks like they live at 500 Gonesita Circle, within the Gonesita community. Looks like they're making some arguments here and more comments about the things.
Water and traffic.
Water and traffic, they are nearby. We have allowed for Gonesita Property Owners Association to participate as a witness, although they are represented by John Knorr, but not as a party with standing. These people live within Gonesita. They've not come to tell us anything differently. My instinct is that we approve them to participate as a witness, but not as a party with standing.
If I may,
Excuse me, just a second. Did you have something to say, sir?
I wanted to comment on this application before the vote was taken, if I could.
Please, sir, go ahead.
So one of the things, and I don't know if Mr. Wallet, my understanding was he was going to be on, so there may have been an access issue, but I'll note for the council on, I guess this was page 3 of the application, that they note that they have already been experiencing water availability issues with their wells currently. This isn't hypothetical. This would be a factual allegation that they have experienced it.
Okay.
And in relation, and so the distinction there comes in that's not hypothetical. They're not saying I'm fearful of this, but I have had this problem. And then in relationship to 994 some odd units and the draw that would come off of this property for well water, I mean, I think on behalf of my clients, we would submit that this applicant has alleged special and unique damages because they have had well availability issues already. That's not like everybody in the community. They are in the Gonesita Property Owners Association, so they are in close proximity. I think within 1/10 of a mile of the project is where the well for those properties is located. And so I would offer that to the council when making that determination versus other allegations that have been made that are more generic about I'm concerned about this or I think this might happen.
Thank you very much, Mr. Nord. Do you have any comments on that, Mr. Justice?
I do have comments. I'm actually a little bit surprised. We had this discussion as part of the stipulation to try to expedite things. That's the reason why the association is a participating witness, not a party. So I'm a little bit surprised by Mr. Nord now touting someone in the community being a party. But still, what you have in this affidavit is an unsubstantiated claim that this development and the impact from this development will be detrimental to this property. So it's cause and effect that is unsupported by an expert or a witness with proof. You have a fact of a well going dry. I believe one of the previous, Mary Ellis just said that about her property. And we all agreed that she should be able to ask questions, participate, but would not be labeled withstanding. So again, the obligation is to show up today with some proof of a link between this development being a problem and their property that's unique. So I would respectfully ask that we be consistent and allow them to participate as a witness, but not as a party.
Thank you very much, Mr. Justice. Dave, have those comments by council changed the motion you were about to make? Okay, and what was that motion?
I'd like to make a motion that William Wallace and Susan Graham have permission to participate, but notwithstanding.
Okay, so that motion was that this Mr. William Wallet and Ms. Susan Graham participate as in the hearing, but notwithstanding as witnesses.
Second that motion.
Mr. Dews seconds that. All in favor? Unanimous. All right, moving on to a Miss Susan Hamilton. Susan, are you on the Zoom call today? Seems that she is not on the Zoom call. Looking over this application, there's a number of marks, but that she did not receive a letter. I mean, I'm pretty sure she does not have a special interest in the property, but she is alleging that she will suffer special damages of light pollution, noise pollution, and road access during construction to her home, which is in the Gonaceto community. The damages are traffic and loss of ridgeline, trees, natural habitats, water, more about the water, noise pollution, light pollution, runoff, internet speed. And she is, she reminds us that she's part of Gonaceto, which is, our contact person is Paul Anderson. Mr. Knorr, do you have any comments on this?
Not on this application. No, sir.
No. So this is another person in Gonaceto. Oh, excuse me, Mr. Justice, do you have any comments?
I think we would be fine with the consistency with how we're dealing with Gonaceto by including them as a witness, but not necessarily with a party status.
Okay, thank you very much. So for consistency's sake, this is another Gonaceto resident. Do we want to allow them as a witness, but not as a party with standing? Okay, could someone make that motion, please?
Motion to approve Susan Hamilton as a witness.
But not as a party with standing. Okay, so Glenn has made that motion. Do I have a second? Dave has seconded it. All in favor? Aye. Unanimous. Okay. Moving to next in our list, it is Connie L. Hawkins and B. Keevan Hawkins. Keevan, are you on the call? While we get Keevan up on the call, if he is indeed on the call, he did receive a letter from the Jackson County Planning Department. He is alleging that he will not suffer special damages, but would like a chance to be heard. I'll tell you, as he's a friend of mine, like what I know of his situation is very similar to those folks on Bustle Lane. So are there any comments by either of the two parties with counsel?
I don't have anything.
Nothing?
Mr. Chair.
Nothing. So it's really our decision whether to admit this gentleman and his mother as witnesses who would have a chance to ask questions, or as a party with standing. I mean, I can tell you from my knowledge, he would have a very similar situation to the Bustle Lane people that we admitted as parties with standing. So for consistency, my instinct is to admit them with a party for standing, and if they choose to show up and speak and act on that, that's their choice.
I think we allowed the people on Buffalo because they backed up to the property they were adjoining.
Yeah.
Is Mr. Hawkins' property adjoining?
Yeah. He's below it. He's below the grade. He's on well water that's below it. He's got all the, like there's Bustle Lane right there. And then 2 properties up along 107 North. That's Keevan's shop. And then they also own the property across the road, which is where their well's located.
Okay, well, if he's an adjoining property. member,
Downhill.
I would think he's.
Yeah. I don't think he filled out his application right, but still. All right. Okay, so we've made a motion, not as members, but as parties with standing. Dave Bond made that motion.
Before proceeding on that, remember that we've got to have a finding of what their special damages will be. And we don't have it on the application. So we're going to need, someone's going to need to be able to present what those special damages, what makes this particular application different from the others in order to have the information needed to admit them with the party.
Well, it seems like they would follow all the same criteria as the Bustle Lane people.
Well, and that's fine.
But if there's no one to argue it, we should just.
Well, just spell that out. You can spell out what the special damages are. We just need it in conjunction with this property.
Landslide, traffic, water.
That was what I was going to suggest, is you could reference that if you wanted to get to those damages for the record.
Mr. Justice?
So the problem with this is not just ceremonial. There are important reasons to go through this analysis, and it's a big deal to have standing, because if you have standing, then potentially if there's any lawsuit that follows all this, unfortunately, you have to be named, whether you want to be named or not, because you're a party with standing. So you will be lumped in, and you may not want to be lumped in. That's just one example, but it's not just ceremony. I would respectfully say to this gentleman, his application says, I don't have special damages. His application says that. I do think he should be able to ask questions. The reason that we dealt with Bustle Lane, if you remember, that was a stipulation to expedite things. We stipulated to the Ms. Johnson because we stipulated to expedite things. Yep. So I would respectfully request that you consider giving him status as a witness, because his very application says an admission that I don't have special damages.
Not at this time, ma'am.
Not this time.
Not at this time.
I don't even remember what I put on this application, and it was.
But you're here. You're going to be able to speak up when you're called. Mr. Hawkins chose not to participate today. We don't know the reasons, so we're doing the best we can with the application and what we know of his property. Heather, do you have any thoughts on this before we?
No, I think, again, it's not on his application what the special damages are. If you decide to proceed in that way to show to say that he has a party with standing, then you as a counselor are going to be having to fill that in for him. And so, again, it's up to your decision, but I think you've heard the reasons for a pro and con for that, moving forward with that.
Okay.
You setting a standard or a precedent.
Yes, for somebody who's not here to present and somebody who did not fill out the application and stated on their application they don't have special damages.
So we are setting precedent if we approve that.
Okay, so where were we? We had made a motion and we had seconded it. Okay, so we went into a period of discussion. So could Dave modify his motion at this point, or should we vote on that motion and then make a new motion if we?
His motion was not seconded. If he wants to just withdraw his motion and make a new motion, that might be the cleanest.
Okay, Dave, is that what you
Would like to withdraw, make a new one.
and the new motion you'd like to make?
That Keevan Hawkins and Connie have permission to participate but not members with standing.
Okay, do I have a second for that motion?
Second.
Okay, Glenn has seconded it. All in favor?
Aye.
All right, unanimous. All right. All right. Moving on to Mrs. Mary Hotelling, of 206 Swiss Lane. Is Mary on the Zoom call? Okay. As we see if we can get her or not, we'll look at her application. She says 206 Swiss Lane is there at the south end of Lake Glenville. Yeah, over there by Trillium. So she did not receive a letter from the Planning Council. She is not alleging that she will suffer special damages. It is my instinct that we just thank her for her concern, but we do not allow her to participate as a party with standing or as a witness. Do I have any agreement or thoughts on that? Okay, so if we could get a motion to just vote that she is not a party with standing, we'll just move on from there. Could I get that motion, please?
I'll make a motion that Mary Hotelling, sorry. I'd like to make a motion that Mary Hotelling is not a person with standing in this case.
Okay, do I have a second?
Second.
And
Okay, all in
before
favor?
voting, you might want to make sure none of the other parties.
Council?
No comments from myself.
Okay, all in favor? Unanimous, is that a yes vote from you, Dave? Okay, unanimous. Moving on to Miss Sarah Jennings. Sarah, I thought I saw your name on the Zoom call.
I'm here.
Okay, we see from your application that you did receive a letter from the Planning Council and that you live at 463 Monte Vista Road. Are you alleging that you're a party with standing because that box is not checked, or are you just seeking to participate as a witness?
I am asking to be a party of
Say that again?
standing.
Okay. And what special damages are you alleging that you would suffer?
Well, and since my application, I've become aware that the development has been they are under contract for the 22 acres that is behind our property. So we actually we abut on two sides, on the phase 3 side on Monte Vista, which is the small piece that is on the opposing side of Monte Vista from the main development, as well as the 22 acres that comes off of 64. So we actually have this development on two sides of our property. I think we have just some concerns. My husband and I do. We own 7 acres in between these two properties, and we bought in a small community that we will see a substantial amount of construction for likely 5 to 10 years, and so just the concerns that go with that, as well as erosion from both sides, more so from the 22 acre side, because there's about a 10-foot bank that separates that property and our property. And then we do have a stream that separates the main development from our property, and just how that will affect that waterway, as well as security with the substantial amount of traffic that we will see both in the construction phase as well as in the final phases when all of the new properties will be opened up. And then as far as long-term concerns, just property value, because of the high density of that development and what that could potentially do to our home and land value.
Okay, thank you very much. Before we discuss as a council, are there any comments from the two parties represented by council?
I'd have a couple questions.
Yes, Mr. Chairman, I have comments. First off, the 22 acres that,
Go ahead.
the 22 acres that she speaks of is not part of this development application. So it's not part of the mix of this development that's before the council. So raising that as an issue is completely irrelevant because it's not part of any development application. Secondly, again, you have to remember that damages generally requires some probative evidence of a property value decline that the General Assembly has said this is one area where you do need to have expertise. That as a layman, you're not allowed to present evidence that's competent in this area of things. So there's no expert here to show damages. And with all due respect to Ms. Jennings, the things that she talks about, I believe are concerns that the community shares about construction traffic, the things generally dealing with the construction of a development. And so with all due respect, I would respectfully ask that the council consider her to be a participating witness rather than someone who is proven with evidence standing.
John?
Ask a question.
Go ahead, Sarah.
That was Mr. Justice, am I correct?
That's correct.
I wanted to ask, I believe Mr. McCauley mentioned the 22 acres in the November meeting. Am I mistaken about that, or was that in the community meeting prior to the planning council meeting?
Mr. Justice?
It was not mentioned at the November meeting, and it is not part of this application. It is not part of what this council has to deal with for a development.
But is it part of the full plan?
No, it's not part of this development.
Okay. Heather, your thoughts on this?
I'll look to Mr. Jeleneski, and I believe he's already confirmed that 22 acres is not part of this application.
Okay.
If down the road it is determined that it becomes part of this development, some connected, then they will have to come back and start all over with those adjoining properties having notice and being able to have an opportunity to participate with standing. But it is not part of the current application.
Okay, so
in front of you.
accepting that, so we've established that, but
Mr. Chair, if I may.
just 1 second, I'm going to come right to you after this. But that piece of land in between their property and Monte Vista Road is part of the PIN number that's part of this development. Everybody agrees on that. So she is an adjoiner. I mean, whether she's adjoining on both sides or on one side, she is an adjoiner. I mean, we could all agree on that. All right, Mr. Noor.
That was exactly what I was going to point out, is that I think she's adjoining property owner regardless of whether this 22 acre parcel is in that. And she is, so I'll go on to just a couple questions for Ms. Jennings. Ms. Jennings, have you experienced any water availability issues on your property currently under present conditions?
We have only owned our property. We purchased it in 2020, so we don't have a long-standing amount of data to go by that. So we have not at this point.
Were you made aware of any concerns like that when you purchased the property by the prior owners?
Objection. That actually would be hearsay. So
the rules of evidence don't apply in quasi-judicial hearings this way, and so that can be allowed if the board will allow it.
Heather, do you have a thought about that?
It is up to the council to determine what can be heard, and you can hear evidence that is hearsay. You just have to give it the appropriate weight.
All right, we'll hear Ms. Jennings' answer to that.
We were not told of any issues.
Okay.
Our well is shared, though.
Okay.
Go ahead. Sorry, I didn't mean to cut you off.
No, it is a shared well.
I don't have any other questions for this witness.
Okay. So just because it does not say on your application, before we make our determination, Ms. Jennings, what special damages are you alleging that you would suffer?
We will have increased and I think, in my opinion, substantial construction, traffic, and concerns, as well as reduced security and erosion concerns, as well as property value on the long term.
Okay. All right. Thank you very much, Ms. Jennings.
Thank you.
So Ms. Jennings is asking to be admitted as a party with standing. Do any of the council members have any thoughts on this before I call for some kind of a motion?
Can I ask
Yes,
Ms.
please.
Jennings a question? Ms. Jennings,
Bob, if you'd use the microphone.
hi, Ms. Jennings, you mentioned about erosion. You have some open water. You have a stream on your property. Do you know if it's shedding or from the proposed development to your property, or I'm not sure how the topo works on that. Can you?
That's a great question. I actually am not aware. I would imagine it would have some effect because it will go behind. It actually will separate our property from the parcel that is proposed to have, 15 homes on it with the retention pond. So it will separate the two, our property and that piece.
Thank you.
There's a stream there. I mean, just from knowledge of that area, and I actually sold the Jennings their house, it is downhill from the ridge line that is the principal ridge line running through this property. I mean, that's just incontrovertible. All right, any other questions for Ms. Jennings from the council members? All right, so we need to get a little bit of a feeling if we're looking to admit her as a party with standing. I mean, she is an adjoining property owner. I mean, she is downhill from the property. She is claiming to have a shared property line that is like a running stream. Based on that, do we think that she is a party with standing and not just a witness? I'm seeing a mix. Nods?
Yeah.
Nods. Okay, if we are going to admit her as a party with standing, if I could have a motion to that effect, please.
Motion to approve.
Okay. We have a motion to approve her as a party from standing from Glenn, and it's seconded by Mark. All in favor?
Aye.
Okay, it's unanimous. Thank you, Ms. Jennings. Moving on to Steve Johannesson, Mr. Stephen Johannesson, who is listed as in person, but I'm told that he is participating by Zoom today. Steve, are you there? Okay, as they find Steve, we'll look at his application. He did receive a letter from the Jackson County Planning. He has an interest in the party. So
I'm here.
Okay, thank you, Steve.
Hello.
We're just looking over your application. Go ahead, present your thoughts.
Well, in looking at this property development, the scale of this is so large that it really has me concerned on a number of different issues. But first, I'll start with the fact that even though I'm not an expert, I've been in business for 15 years in the same location, and I know the traffic patterns on this road intimately. And they are seasonal, but it is really, really, really important to note that the traffic is there's a congestion point or a choke point at Frank Allen Road for the left turn lane, as everybody knows. And so what happens is the more traffic there is, the less business we get because people cannot turn onto our property. So that's one issue in terms of the traffic. Now, we've had traffic analysis done on the road. I'm not an expert. I would say that I'm an expert anecdotally on the front of my property, but in terms of the traffic actual numbers, the DOT has actually done traffic analysis on this road over the years when we were doing the charrette and some other projects that the community was working on. So we do have older traffic assessments of the area, but moving forward, we have two really large developments on South 107 down at the High Hampton area, and then right across the road from it, about 900 home sites. So we know that the traffic is going to really increase dramatically as those developments finish out. So I would submit that the traffic, if they have not created a plan for mitigating the traffic during the construction, at that intersection and at the other intersection where Monte Vista Road intersects 64, that traffic will be impacted dramatically in a negative way, and this will impact my business.
Okay.
Also, I had been planning on selling this property as you know, I'm getting ready to retire in a few years, and I've had several offers in the property, and I want to sell the property. If this construction is going on for 10 years, it's going to depress the value of the property until the project is completed. So for the 5 to 10 years this project is going on, my property value will be depressed. We also have secondary impact on my property, including stormwater runoff, which will be a problem. I am downhill. If you guys notice where the property is, it's directly across the street from where the development is. So we have stormwater issues now, and this will be exacerbated by construction. I'm concerned about groundwater contamination. They're planning on putting in septic systems, in-ground septic systems. It's my understanding that they will not have access to the Horse Pasture River project. There was an attempt made to be engaged with that, but they were told that the town actually has priority over the development, so that they're not going to be able to get the septic from the Horse Pasture River plant that's going on in a few years. So they'll have to build their own groundwater dispersion techniques, and I'm right downhill from that. The noise impact from the construction will be obvious. I mean, everybody knows how that is. And then finally, the property that we're sitting on is, I guess for lack of a better word, it is adjacent, even though it's across the street, but it is right across the street and directly impacted by this. So I'd ask that people just consider that in terms of the application. Thank you.
Thank you, Steve. Are there any comments from the parties represented by council?
Mr. Chairman, I would just respectfully ask the council to consider this individual as a witness rather than a party. Again, the obligation today is for there to be probative evidence, usually through an expert linking the concerns and bringing it to life from this development. I will say that to the gentleman's point about traffic, as you all probably know, in 2021, DOT has a very thorough vetted process for traffic analysis and driveway permits that we've been going through, and that will be presented to the council. We also have very extensive regulations dealing with stormwater and settlement that we have to abide by. With all those things being said, this witness, again, is talking about concerns of traffic and other things that are generalized concerns and without proof at this point. So respectfully, I ask council to consider this person.
Excuse me, council. I am giving you testimony that is direct, experiential. This is not anecdotal. This is not I've heard this or I understand that we have a problem in town. This is a direct problem right now to my property as we speak. It has been a problem for years. And what I'm telling you is that it will get worse. The problem already exists.
Okay.
If I may ask a couple questions of the witness.
Right. Thank you, Steve. Were you all finished there, Mr. Justice?
I don't set the rules of engagement here. There is a statute that says for traffic, you have to have a traffic engineer, with all due respect to this gentleman.
Okay, thank you.
Well,
Mr. Knorr, please go ahead.
I'll slightly disagree with Mr. Justice on whether you have to have a traffic engineer in order to give fact testimony about current conditions on the property. If someone lives in an area, they can absolutely testify to what they've seen, what they've experienced, what they've heard as a fact witness. And so I'd like to ask a couple more questions of Mr. Johannesson related to that. Mr. Johannesson, you mentioned traffic as one of your main concerns. Let's get into the details of that. You said you operate a business on the property, is that correct?
That is correct.
Okay, and you had mentioned that you currently, under current conditions, have customers having difficulties accessing your property during the high season, is that correct?
That is correct. It's 100% traffic related.
Let's go into the details. Tell them what difficulties currently exist. What kind of wait times do customers experience under current conditions?
Well, let's start with there's a stoplight at Frank Allen Road, and we have a 2-lane highway, 1 lane going in each direction. When the traffic light is green on Frank Allen Road going north on Highway 107, anybody who is waiting to do a left turn has to wait for all of the traffic coming off of Highway 64 going on 107 south. And so what happens is you have a run of traffic going east to west on 64 will turn left onto 107 South, heading towards Frank Allen Road. Anybody trying to turn onto Frank Allen Road or into our property has to wait for all that traffic. Typically what happens is during the season is because of the timing of the lights and the quantity of traffic, people don't get through the intersection. It usually takes them a couple or 3 lights to get through the intersection.
Do you
And
find
so
that
with
causes
that being the case,
frustration for you?
while they're stopped.
Go ahead. I didn't mean to cut you off. Sorry. I thought I heard a pause.
No, that's all right. And what happens is the people who would like to get in to our property can't because of the traffic that's going in the opposite direction. There is, I mean, obviously, so the solution to that would be for DOT to fix the road, but because that's not what we're discussing. I'm just telling you what's happening now. And so every time in the season, when we hit peak season, the traffic can't get to our store.
So under current conditions, have you experienced potential customers choosing not to use your shop as a result of the traffic congestion under current situations?
Yes. I've had customers tell us they couldn't get in, so they decided to come back the next day, or maybe they didn't come back at all if they were here as a visitor to the area.
And have you reviewed the site plan?
And we rely on tourism primarily.
Have you reviewed the site plan for the proposed development?
I have it right in front of me.
And is there an intersection for this proposed development right at the current intersection of Frank Allen Road and Valley Road there and 107?
There appears to be a main intersection that directly connects to Frank Allen Road, across from that Frank Allen Road on 107, yes.
And I believe in the application, it mentions something like over 900 residential units and in excess of 1,400 parking spaces for the proposed development, correct?
Yes.
So is your concern related to traffic based on your factual observations that you've had over the years related to access to your property, and then the compounding effect of the traffic flow that'll come off of this development due to those over 900 dwelling units and 1,400 parking spaces, and your close proximity to that intersection versus everyone else that uses 107?
That is correct. I mean, if they're going to dump out into that specific location or any place along the road there, they will dramatically impact the traffic patterns. And I would suspect that an analysis by a traffic expert would show that the traffic would move much slower through there.
Have you ever had accidents on 107 that made it difficult for customers to access your property?
Not in front of our store. I mean, there have been a couple of rear enders. You know, somebody wasn't watching the light or something like that and banged into somebody, but no major accidents. Not in front of our store.
Those are well, one other question. You are down gradient from the development as a whole, correct? You'd mentioned flooding and stormwater.
That is correct. That is correct. Our well water pulls from the groundwater flow off of the ridge across the street.
And do you currently experience stormwater or flooding issues coming off of that property site related to yours?
Not currently, because the ground is held together by the trees and the landscape. You know, they tend to be a buffer or a retainer for the dirt to keep it from running off. But as soon as that gets taken off, we are downhill, and there is no drainage system in the roads to handle that. So I'm not sure exactly where their runoff would go.
So your concern is that because of the impervious surfaces that'll result from the development, additional stormwater will end up on your property, versus under current circumstances, it flows into the ground through the vegetated location, vegetated condition of the property.
Correct. The natural percolation of the land allows the water to soak into and then run in an underground aquifer.
Okay. Those are my questions.
Thank you very much. Steve, just for clarification, it's my understanding that you don't, while you did operate a business there for a number of years and you clearly own the property, you don't operate a business there right now.
I do operate a business. It's cashiersnorthcarolina.com.
Okay. Very good. So
that's my business address. There's no sign up there, but there actually, for some clarification, there is going to be a sign going up this spring.
All right, very good. All right, so it says here in your application that you will suffer specific damages, but that the damages you will suffer are not distinct from those damages to the public. So just to clarify, are you asking to be a party with standing, or are you asking to be a witness that is able to ask questions?
I'm asking to be a party of standing, and I don't agree with your characterization. My loss of business is tangible. It can be proven. If I need to, I can show books, but right now we can't do that because the project hasn't started yet. So I can't really get into how it will be impacted, but I know it will be.
Mr. Chair, if I might
Yeah,
ask
John.
a follow-up question, Mr. Johannesson, based on your question.
Go ahead.
Mr. Johannesson, I know you checked the box on your application. Sometimes these applications can be difficult to figure out what you're supposed to check and what you're not supposed to check. From what I'm hearing from your testimony today, you might change the checkbox on the second page of your application where it says that I will not suffer distinct damages to you will suffer distinct damages. Would that be accurate?
Let's see. Did I check that wrong?
Yeah, I think you may have.
What I'm saying is I will sustain damages. So if I check that incorrectly, I apologize for that.
Okay, I think we understand that you're saying that you
I
will.
was in a little rush to get this
special-
thing in. We didn't have a whole lot of notice to get these applications together. So
Yeah, so you're alleging that you will suffer special distinct damages.
yes.
Okay, all right, based on that,
Mr. Chairman, can I ask a question since?
please, Mr. Justice.
Sir, you talk about traffic. Can you tell me how your traffic impacts that you're concerned about are any different than the property immediately to the north or the property immediately to the south along 107? How are you different than those property owners?
I would say I'm probably not. I'm not sure exactly why they haven't responded to be have standing in this, but I'm sure they suffer the same distinct problems that I do.
So following up on that, how far up 107 would you go to say those people are different than I am and do the same thing going south? I'm just trying to figure out along 107, where is it that you're saying?
That's real easy. Anybody who's across the street from the property has the same problem. Across the street from this proposed development has the same problem that I do, down to the edge of where the development ends. And when your development ends, those other properties don't have that same issue because they're small retail, real estate offices, things like that, residences. It's different. It's not, those don't impact the traffic on one side or the other because those are low traffic, I guess you call them uses or of the property. That, residential, you don't have a lot of traffic. Retail, you don't have a lot of traffic.
So the business you speak of, the dot, whatever it was you said that you opened, what is that?
What are you talking about?
What's he was asking what the name of your business that you have at this location is, and what is the business?
There are two businesses at the location. We actually had an antique store there up until a year and a half ago, and we now are leasing the store out to another gift store. And also, I have my business cashiersnorthcarolina.com, which is the community website, is based out of there as well.
So, Mr. Chairman, I'll just make two quick comments.
Please.
One of the cases that I know in the handwritten materials y'all get dealing with standing there's I believe you get because I've seen it. There's some legalese and cases that are referenced in the material you get. And one of the cases is a case called Cherry versus Weisner, and it dealt with a neighborhood in Raleigh. And the issue was a lady who was across the street from a house that was being reconstructed in a historic district was complaining about that house not conforming to the historical district standards. And she was immediately across the street, and it was immediately in front of her. And she was saying that the people in my neighborhood are going to suffer from this house being built in a way that's not consistent with historical standards. The courts found that person did not have standing, even though they were directly across the street, even though you could directly see the house in question, because of the allegation that other neighbors of that property shared the same concern. So it truly has to be very unique. And so respectfully for this individual to say, I'm along 107, and these are the concerns I have, I don't believe that's unique enough for purposes of standing. And respectfully to Mr. Knorr, I have been involved in cases that have gone to the Court of Appeals. I know for a fact that for traffic, you have to have a traffic engineer to take fact and then draw a conclusion. And that is absent from what this witness is saying. There is no traffic engineer to provide that probative evidence that is necessary.
Thank you, Mr. Justice. Heather, do you have some thoughts?
Can I ask a question?
Just a sec. We'll come back to you, Steve. Heather's just
I would
gonna
like to respond at some
the
point
county
too.
attorney and
Thank you.
Mr. Knorr just hear some of their thoughts on this point of bringing another case into it.
A couple of things. One is, Mr. Justice correctly characterized the Cherry case. That is a case most of us are familiar with. However, a couple of points here. One is put traffic aside for a minute. Excuse me. I believe Mr. Johannesson testified and gave a couple of characteristics about his property, talking about the runoff, the location, the downhill that were similar to Ms. Jennings. And I think one of the things, regardless of what happens down the road, if you're wrong in a decision you make and a court determines that, that's fine. We'll deal with it at the time. But one of the things that's most important is that you're consistent in who you allow in with standing or as a witness. And what I heard was Mr. Johannesson, aside from traffic, gave similar testimony to that of Ms. Jennings, who you chose to let in as a party with standing. With regard to the traffic, it is correct when we get into the substantive hearing, there is case law and other information that you'll need to hear from experts in order to make decisions on certain issues, but we're not at that point now. We're talking about standing and what makes his property unique, different, special damages from others in the community, not adjoining, not next to this property. Now, I would, again, it's in your decision. It's up to the council to make the decision. I just ask you to be as consistent as you can across the board.
Thank you, Ms. Baker. Mr. Knorr.
If I could share my screen for just a second on this, I just want to bring up a case for the council to look at. This is the Mangum case. This is a North Carolina Supreme Court case. So Cherry is a court of appeals, but what that means is that nothing that Cherry says can overrule what the Supreme Court says, okay? So I'm going to just throw this up here real quickly. There we go. Okay, so this case here, again, as I said, this is the Mangum case, and I'm going to just pull out, this is a case that talks about standing in cases like this. And what I'd like to point out here is in talking about the kind of damages you have to allege, I just want to pull out right here. This is the language the Supreme Court talks about, and I think Ms. Baker just talked about this. For special damages, standing through their testimony regarding increased traffic, increased water runoff, parking, and safety concerns. These are the things that the Supreme Court has found are acceptable to allege standing in the case. So I want to make sure that while we're referencing Cherry can't overrule what the Supreme Court held in this case. That's the law of the land.
Okay.
So I think that Mr. Johannesson has met that burden.
Would you have different objections based on this, Mr. Justice?
Yes, with all due respect to Mr. Knorr, I don't believe he's correct. Even the Cherry opinion has continued to be cited and recently was upheld in a case that went to the Court of Appeals, and then it went to the Supreme Court for the Supreme Court to hear it, and the Supreme Court decided not to hear it. This was an asphalt plant case. And at the end of the day, in that Mangum case, you still had, that was a situation of an adult entertainment facility that was operating. And there was evidence of how that operation was already currently affecting the properties in question. So it was linking the actual development was already taking place to the concern expressed by the property owner. That's what's absent here, is you don't have a link of actual impact from this development to the property.
Understood.
You have speculation about that. So with all due respect, again, I'm asking that the council consider this person as a witness. Now, I will agree with Ms. Baker that you made a call regarding Ms. Jennings, and I would agree with what she said, that for what Mrs. Jennings did, for the allegation of runoff, that you allowed Mrs. Jennings to be a party. So I tend to agree that at some point the die may be already cast here based on what you've done.
Okay, so based on all that, and for consistency, it seems like, you know, we appreciate attorneys and these points of law, but it seems like the biggest point is that if we've allowed Ms. Jennings for consistency, we need to allow Mr. Johannesson. Steve, did you need to make another comment before we move on and make a motion whether or not to accept you, or have you made your points?
No, if nobody has any other questions, I'm done.
Okay.
One quick clarification, Mrs. Jennings' property was adjoining?
Yeah, but I believe when
Adjoining?
I believe when there's a road in between, do we still consider it as adjoining, Heather? Ms. Baker?
We did, or the planning department did, for purposes of sending a letter. He was sent a letter. We determined that it was adjacent, I think is the actual term in this case.
Okay. Does that help you, Bob? Mr. Dews?
Yes.
Okay. So I recommend that the council, that we make a motion to approve Mr. Johannesson as a party with standing. So if someone agrees with me, if I could get a motion to that effect.
Yeah, motion to approve Steve Johannesson as a person with standing.
Okay, do I have a second? Okay, it's been seconded. All in favor?
Aye.
Okay. We've been at this for a little over an hour and a half. At this time, I think let's take a adjourn for 15 minutes and pick it back up at about, trying to do math. Let's say at about 11:10, we'll pick back up. Thank you. Back up with 11:10. We'll pick back up with a Miss Juliana Kaufman. Juliana, we have your application in front of us. Could you, if you're here presently, if you could come up to the microphone. Hello, ma'am. How are you?
Great, yeah.
Very good. So you, looking here at your application, you did receive a letter from the Jackson County Planning Department. You're alleging that you will suffer special damages. You are right across the street from the development. In many ways, without
I'm
going into
also
the
next to it because of the parking lot
yes,
adjacent.
yeah.
I'm
So in
across
many
the
ways,
street
your
and next to
application and your situation would be very similar to Mr. Johannesson and Ms. Jennings that we've previously allowed to participate.
Actually worse,
as a person
because
with standing,
it
or,
is
or, a,
worse.
or a higher standard. You're saying?
It is worst because the light from Frank Allen and the crossroads, and I'm in between.
Could you adjust that microphone just a little bit down too? I know it's not going to help me here, but it's going to help the people on the internet here.
Okay.
Go ahead.
Anyway, the traffic since I moved there 18 years ago has increased tremendously. And it is a parking lot, 107.
Okay.
And between the changing of the lights, it's impossible to get in and out of the parking lot. Customers sometimes call me, sorry, I'll come back another time.
Okay.
And also with the constructions going on, the dust, the pollution, I used to keep the door open, no longer because of all the noise, the pollution, and the traffic.
Okay. So we're going to give both of the members of council an opportunity to speak, but I mean, I see Ms. Kaufman's situation is very similar to those other two people. Mr. Justice, do you have different objections that you've had to Mr. Johannesson and Ms. Jennings? Okay. Mr. Noor, do you have any additional questions or?
Just one additional, I think it'd be very limited. I won't go into the same detail as I did with Mr. Johannesson. If I could share my screen real quickly. Okay. Okay. I am going to show, this is the site plan, Ms. Kaufman, correct? For the proposed development as you've reviewed it?
If you could just speak up a little, Mr. Noor, because
Ms. Kaufman, have you reviewed the site plan for the proposed development?
Have I what?
This picture up here, your property where I have a red laser, this is your property, correct?
Correct.
Okay. And right across Marigold Street is the back side of your property
Yes,
here, correct?
correct.
And so this proposed development actually has buildings within that Marigold Street, correct?
Yes.
Do your customers access your property for business along Marigold Street?
No, they come by 107.
Okay, but could they use Marigold Street if they wanted to currently?
No, that becomes a parking lot in the summer.
But because of the traffic?
Yeah, or because there is no parking either, and the traffic. So people park all around there, even people that are not shopping in my store, just to go to the farmer's market, to go all around.
Okay, but that parking, people use that to get to your store sometimes during the high season?
More to go to the other shops, actually.
Okay. Those are my questions.
Because I have a parking lot in the front.
thank you very much, Mr. Noor. Based on what who we've allowed to have standing so far, My inclination, Ms. Kaufman, is to allow you as a party withstanding without talking to the rest of the council. Do you want to participate as a party withstanding, or do you want to participate as a witness that is able to ask questions? So it's really,
Witness.
being a party withstanding is really like a higher level. You're equal to these.
I like to have both, actually.
So you'd like to be a party withstanding. You would just want the higher level. So Ms. Kaufman would like to be a party withstanding, and based on those folks that we've already allowed in, it's my inclination that we let Ms. Kaufman be a party withstanding. Do I have a motion?
That we allow Ms. Kaufman to be a party of standing.
Okay, do I have a second?
Second.
All in favor?
Aye.
Aye. Thank you, Ms. Kaufman, your party withstanding. Moving on to Brent J. Mills.
That'd be me.
Hello, Mr. Mills.
Hello?
Let me just get everything in front of you. Okay, I see here that your property is at 105 Ganasita Circle.
Correct. That's the entrance to Ganasita.
And are you part of this Ganasita Property Owners
No.
Association?
No, we're in a separate development called Hidden Creek.
Okay.
It was
Can
sold
somebody
separate.
show me where the location of his property is?
Right across from Jane Nardi's property. When you come up Ganasita, our property is the road right in front of you, is the house right in front of you. We're on
Okay.
the left-hand side. We own the acre and a half on the bottom of Ganasita.
Okay.
That's our property right there.
Okay, so you didn't receive a letter. You're not adjoining, but you're very close to the
I'm
proposed
100 feet away from the property, couple hundred feet away from the proposed development, and I'm at the entrance to Monte Vista and Ganasita. I have 4 residential homes on that piece of property right there that will be directly affected by this.
Okay, and you're seeking to participate as a party withstanding?
Yes.
Okay. The special damages that you are, it says right here, high density residential and commercial traffic. So,
There's more.
and then it also says water, sewage, noise, and traffic. Those are the damages that you're alleging that you would suffer, and then that would be distinct from the public at large?
That is correct. And I'm a developer, a North Carolina licensed general contractor, and a North Carolina licensed real estate broker with an active real estate firm.
Okay.
I consider myself an expert witness. My
Okay.
wife's car got totaled coming out of Monte Vista trying to make a left-hand turn on 64 this year between May, June, July, and August. The 8 residences that's on our property are on a spring, not a well. I feel it'll be directly affected by a couple thousand residential homes being built next door.
All right, sir, that seems to be good evidence.
Any-
Go
That's
ahead.
all.
Do you have anything else to add before I throw it
No,
to
sir,
the-
they'll probably do it for now.
Okay. Mr. Justice, do you have any questions or comments?
The Monte Vista Road, where the Ganasita Association and property owners have all testified, we have, or at least this council has treated those folks as witnesses rather than parties. You've heard me ad nauseum talk about the level of proof that's required at this stage and the uniqueness that is required to be presented, that you're uniquely affected. Traffic is a general concern along Monte Vista. It is just not that. And the whole discussion about wells and sewer, it's really a shotgun blast of concerns that we want this person to be able to ask questions and go through it, but to give this gentleman a party label is inconsistent with what the council has done so far, and I believe is inconsistent with the law.
Okay. Thank you, sir. Mr. Knorr, do you have any questions or comments?
Just more of a comment.
I have one more statement if I can make a statement.
Just a second. Let me make him, and then I'll
Okay.
be back to you.
Just my comment is in general, because I do have a client, Ms. Mengi, who is on Monte Vista. We obviously disagree with the characterization that everyone on Monte Vista, that creates this generic type of problem. No, Monte Vista is a separate road from the rest of the community. The standard for standing is damages distinct from the community, not from your neighbor, not unique, but distinct from the community. So you would expect folks who are abutting or using the roads immediately adjacent or adjoining a proposed development to have concerns that are different from folks who might be 2 blocks over and don't use those roads. And so Monte Vista is a unique road in relationship to this proposed development. It is and I just want to make sure that I say that just for the benefit of my clients and how the council considers that testimony going forward.
Okay,
And I'd like to add to that if I could.
go ahead, sir.
I believe on the proposed plan, I saw that they were going to have the septic's holding tank put on the side of Monte Vista Road, which that would put it right in my front yard.
Do we have that plan? Is that verifiable?
Where are you guys going to put the septic holding tank for a couple thousand bedrooms?
Heather, what do we think about this? Does this matter at this point?
I don't think we have that shown on the plans. I don't know, unless Mr. Justice or the applicant wants to address that. I don't think we have that shown on the plans that are before us.
Is that really relevant to his standing at this point?
Well, I agree with both what Mr. Justice and what Mr. Nora have said to you. However, again, looking at consistency, and that's what I would have you come back to, and what have other property owners in a similar situation, what status have you given them?
Yeah, okay. But with that being said, we'll just leave that point about the sewage holding tank alone for now.
Okay, then let me tap on the water one more time. Yeah. Above my lot, the next lot above ours belongs to our cousin. She drilled a well 1,000 feet this year, and it's bone dry. Our 8 houses are on a spring. Springs are going to be the first thing to dry up besides a well.
Okay.
So we have a lot of concerns. We've got 8 residential homes that may be directly affected by the water that will be pulled from the ground.
All right. Based on what the attorneys have said and what Heather said, it seems like for consistency, if this gentleman is seeking standing, that he meets the bar by which we've given standing to some other very close or adjoining properties that have questions about like water, noise, traffic, etc. So it's my feeling.
Michael, just one clarification. What I was saying with regard to consistency was the others on the Gonancita area that were not adjoining property owners, even the association was treated as a witness, will still participate in the proceedings, will still be able to ask questions, but it had, I think the couple that you've given standing to had the adjacent property owner as an additional. It doesn't mean you won't do that in this case, but that's what I was referring to with regard to consistency.
Well, we have 2 standards. We have the standard that we've kind of brought some of the Gonancita properties into, which is that they're nearby and that they will participate as witnesses, but not as standing. And then we have the other people that have been adjoining. So this gentleman is not adjoining. He's quite close. He has several homes on a spring. So we have to determine which one of these 2 groups that we've sort of made de facto that he would fill into. Do any of the other council members have a thought on this?
Mr. Millett, have you attempted to drill a well on that property?
Yes, a year ago, not on my property, but the property within 1,000.
On your property?
Oh, not on my property, no.
Okay, so no, it's maybe hearsay that it's.
Well, the well that was drilled is less than 100 yards from our house. So if I drilled a well on my lot, it'd be 100 yards from where the other one was drilled. That's dry.
Yep.
1,000 feet deep.
Thank you.
All right. We're kind of in between on this one.
Okay.
My instinct is that you have more in common with these people that we have given standing to than you have with the people up on Gonancita that are participating as witnesses. And that was, of course, agreed to in between the two lawyers for expediency, so we didn't really hear that one. They agreed to that in advance, and we agreed to take what they negotiated. This gentleman is asking specifically for himself, and my instinct is based on what we've allowed the other people to allow this gentleman in to have standing. If someone agrees with me on that, let's have the motion in that direction, and we'll go ahead and vote, and we'll see which way it falls. Okay, so we have a motion from Dave Bond that Mr. Brent J. Millis is to have standing. Do I have a second? Okay, it's been seconded. All in favor of Mr. Brent J. Millis being able to participate as a person with standing? All in favor? All right, so it's unanimous. All right, moving on to Jamie and Mark Moran of Gonaceto. Are they participating separately, or are they with you, John?
Mr. Chair, I'm not familiar with them as being, I don't know one way or the other, but they're not one of my clients individually.
Okay. Are they on the Zoom call today?
Yes.
Okay. So far, we've seen members of the
Michael,
Gonaceto.
I don't want to waste, we're part of Gonaceto POA, and we'll adhere to the agreement between John and Craig.
Okay, so we don't really need a separate motion, I don't think, Heather, because they're already part of that agreement.
No, I think they're not part of that. They're asking
No, they said they were, and they would agree to be part of that agreement.
My understanding, and forgive me, my recollection was vague. The Morans are actually referenced in the Gonaceto's affidavit, so they are members of the POA. And if I'm hearing Ms. Moran correctly, she's saying she would be comfortable just as a participant versus having standing.
That's what I heard as well.
Correct me if I'm wrong.
But they would need to be voted on as a party to be a witness, not a party with standing.
Okay, all right, so if it's all right, Jamie, we'll have that vote at this time for you to be a participant. Is that correct?
So just for one question, because I didn't get a moment to talk to John either. Mr. Knorr, because we're referenced, should we be a party of standing or should we be a witness?
I really can't have that
conversation.
That'd be a confidential conversation that you and I should have without everyone else listening online and then in person. But the Property Owner Association has been voted to be a participant. And so what I'd say is if you and your, forgive me, Mark, want to do that individually aside from the HOA, that's your decision to make, but I'm not your attorney for that. And so that's just a decision you'll have to make.
So Jamie, it seems like as a participant, the Gonaceto POA will be able to ask questions. Are you okay falling under that umbrella and being represented in that way?
Yes, that's fine.
Okay. Do we need to have a motion?
I still think they have some confusion. Yes, there needs to be a motion for them to participate as witnesses, not as a party with standing.
Fine. If I could have that motion from a member of the council.
I'd like to make a motion that Mark and Jamie Moran participate as witnesses.
Okay. Second. Do I have a second? I have a second from Mark Letson. All in favor?
Aye.
All right. Unanimous. All right. Moving on to Jane Nardi and Patricia Nardi. Say that again, ma'am. So they were supposed to be here in person, but they are not. So let's refer to their application that they did receive a letter from the Jackson County Planning Department. They've checked here that they have an interest and then made their own box that they're adjacent. They are alleging that they will suffer special damages that are distinct from the thing. And those damages that they are alleging are, oh,
If I may speak, I might be able to bring some light to it. She is my mother-in-law and sister-in-law, and their interests are the same as mine. They live right across from me.
all right, Heather, how do you think we should handle this? Just go by the application because it's not very clear what their special damages are.
Yes, at this point, I think all you can do is go by the application if they who have applied and filled out the application are not here to speak to it.
Have we brought their property up? So it's, their case is basically the same as Mr. Millis. And they've applied to be a party to the action. I assume your objections are the same, Mr. Justice?
Mr. Chairman, since we're only going by their application, and we do have a couple examples of folks not attending and going by their application and taking what they wrote down as the extent of their evidence, if you will, or their reasoning. The reasoning in this, in their request is based on a historical character analysis of the before and after that actually takes place with a lot of developments about change inherently. And I will say that I would contend that the issue of the before and after development and the change that comes with it is something that everybody in the community wants to have information about and may express some concern about. To say this is special and unique to these individuals, I think is misguided. So we respectfully, based on the application, I don't see how they have shown standing.
Okay, Mr. Noor, do you have any comments on this application?
I don't, Mr. Chair.
I do.
Well,
Mr. Chairman, with all due respect, at these kind of quasi judicial hearings, unless you have an attorney present, you can't really speak for someone as a representative.
I would agree with that.
Well,
sir.
I'm sorry if I could be heard on that matter. I mean, I think
Okay.
Mr. Billis he's been declared to have standing. So now he doesn't have to hire an attorney. He can speak for himself and participate to the degree that he wants to, obviously subject to the council's determination on relevancy, substantiveness, and other things like that. But I think I might disagree with Mr. Justice.
I actually
on that.
agree with Mr. Noor on that.
My point, Mr. Chairman, is he can't add to the application with facts or evidence or something to support different reasoning. If he wants to make an argument based on the reasons given, that makes sense.
Okay.
That's fair.
Okay. So do you have a copy of this in front of you?
Of what?
Of their application?
I do not know.
Is it, so look this over real quick. So basically, you can make a point on you can make a reasoning based on their application, but you can't just extrapolate your own points, which we upheld, from that because they're not here.
I actually have inherited interest in this property.
Well, that's different than, I don't know. It seems like while they are very similar to you in the way that they filled out their application, they did not do as good of a job arguing as you that their special damages that they would suffer because they kind of chose to do like a narrative form of discussing things. So they didn't say that they had special damages related to water, traffic, etc., erosion.
But they do because of the location. The real estate location is at the entrance to Monte Vista and Johannesson. She owns that property. She is a local historian. The Cashiers has considered her as a local historian. If anyone in Cashiers knows about the history of Cashiers, it would be Mrs. Nardi.
Yeah, I understand, but I don't see how that qualifies for special damages.
Well,
based on, but see, here's the thing. So what the two attorneys have said, and I'm not going to Heather for that, but they've sort of agreed, is that you can make any points you want as a party with standing. based on what she wrote down here.
Okay, then what the point I'd want to make is that her location is at the same area, but my location is. She has rental properties the same as mine, so without any
Okay.
evidence, it's obvious that her location and her business and her location is going to be affected the same as mine. And that was my point.
All right. Thank you very much, sir. Heather, do you have any thoughts on this?
Yeah, I think the point has been made. You have to base it on the application. They have signed this application, so it's only on the evidence they have presented to you. And I don't know that you have any evidence for special damages before you, although they could certainly participate as a witness as you've done with others.
All right. And that at this point, looking at this application,
Can I make one more point?
one last point, sir.
Both of them are not doing well right now.
Yeah. Well, and
Both cannot leave their home.
all right, well, and we want them to do well. I mean, they're both important members of our community, but nonetheless, we're looking at this application, and based on the points made by the two attorneys and Heather, it seems like there is not like substantial evidence in this application to say that they are suffer special damages. So what I would call for as a member of the council to allow them to participate as witnesses, but not as a party with standing.
I'd like to move that we allow Jane Nardi as a witness and not a member of standing.
Okay. Do I have a second? All in favor?
Aye.
All right. Okay. Ms. Court Reporter, that was seconded by Dave Bond, if you didn't hear him. All right, moving on, we have a Miss Maria G. Pantlow, and her address is 213 Halsted Road.
She withdrew her application. This is the one you have the email about.
Okay, so moving on. So we don't have to, with her withdrawn application, it's just withdrawn. We don't have to vote on it. All right, moving on to Kelly Ryan. Did we have an email on her? I had some name with Kelly on it. What is this? This is, oh no, that was Maria. Oh, that was Allison's email address that I was looking at. Is Miss Kelly Ryan participating by Zoom today that we see? Looking at her application, she lives at 69 New Morning Lane, which is up above the Ganasita, if I understand correctly. She did not receive a letter. She is alleging special damages, and she said, my property is accessed through the Ganasita neighborhood off Monte Vista Road, and therefore will be significantly impacted by the proposed development in terms of increased traffic in accessing or leaving my property and potential impact on resale. That's how she filled out her application. To me, my instinct is that this one is more similar to the Ganasita folk that we're allowing to participate as witnesses, but not as parties with standing. Based on that, are there any new comments from parties represented by council or parties that have been granted standing that are currently present and participating?
No, Mr. Chairman.
Mr. Knorr?
No, Mr. Chairman.
Okay. With that being said, I'd ask a member of the council to make a motion that Ms. Kelly Ryan be able to participate as a witness, but not as a party with standing. All right, that motion has been made by Glenn. Do we have a second? Seconded by Robin. All in favor?
Aye.
Okay. Moving on to Robert Salveson and Susan Benacci.
Bianchi.
Apologize for that mispronunciation of your name if I did.
Susan Bianchi.
Hey, Susan and Robert. Looking at your application here, you did not receive a letter from the planning council, from the planning department. And it says that your address is at 2142 Fenley Forest. It's my understanding that you're right down off the lake there over in Glenville. And it says the damage you suffer are not distinct from the public, and you've written in significant adverse change to the community. It seems like that you're very similar to people that we have not allowed to participate as a witness and not voted have standing. Do you have any arguments to the contrary on that?
Yes, under standard number 5 that you're supposed to be following, significant adverse change to the community is a valid concern.
Okay, where are you pulling that from, sir?
Let's see now. Hold on one second.
He's looking at the standards that you all will consider when
Standards for
determining whether to.
Oh, the one with the yellow highlight.
That the proposed use or development of the land will be in harmony with the scale, bulk, coverage, density, and character of the community. And we have a deep and abiding interest in that particular standard. So we would be willing to if we understand what a participating witness is. I had 2 questions about that. We would be willing to be participating witnesses. The first question I have is, what does it mean that you can ask questions?
Heather? Ms. Baker?
What that means is once we start the substantive part of the hearing, there will be experts that will be testifying and giving reports of evidence to, based on the application to meet those standards, or opposing experts that oppose it. And what that means is if you participate as a party, as a witness, but not with the party withstanding, you will still have an opportunity to ask those experts or those witnesses questions, as will the attorneys and the other parties withstanding in the hearing.
And will participating witnesses who can ask questions also receive notice, like we've received notice of when the hearings are being held, and be able to be on Zoom, which is important here because the distinction of being on Zoom is important because of the nature of internet service here?
Yes, that would be correct.
Okay, then it would be satisfactory to us if we could be participating witnesses under those circumstances.
Okay. Do the parties represented by counsel or parties that are present or on Zoom that have been admitted with standing have any comments, questions, or concerns?
Well, I do have a concern with the answer just given. Parties, if to be a party, you would certainly be giving notice. If there's adjoining, you have notice requirements. So I'm not sure I understood the question that he asked about getting subsequent notices.
They would be on Zoom is the part I was answering. The notice would be if they're here at this hearing, they would know when the next hearing date is. But yes, you're correct. They would not receive legal notice if any are given with regard to subsequent part of the hearings. They would know when the next hearing would be held as a participating witness because they would be there and hear when that is. But I was really answering his question about Zoom. They would receive the link to Zoom, not just have to listen on to YouTube.
Okay, that's satisfactory.
So Mr. Chairman, this presents one of those outer fringe issues that we have said, and we continue to say, and it hold true, that we want to be transparent and we want to give everybody an opportunity to ask questions. The problem is that this gentleman's property falls into the Sean Cronin and one other property that was out Lake Glenville way, that at some point in time, in terms of management of the process, you've got to cut it off because it's not a popularity contest. We're not polling people. And so at some point in time, if it becomes this person allowed to come in, then I'm not sure where the line is on anybody else not coming in to ask questions. Again, if this is it, in terms of asking questions, we're fine with it. But otherwise, the problem is one of precedent of allowing people later on to come in. But my understanding is this may be the only list. So nobody after today can come in on the 25th and say, hey, I'm just like this gentleman. So if that's the reality of this finite list, then our problem is as problematic.
Well, my instinct on this one is to agree with the first point that Mr. Justice made. And while I appreciate you participating, Mr. Salvinson and Ms. Bianchi, like right down the road from you, some people at 208 Swiss Lane and at Honeybee Bend over there in Trillium have asked to participate, and we have denied their application to participate as someone with standing or as a witness, and that's my instinct, that we appreciate your concerns, but that you're not, you don't raise to the level where you're going to participate in this hearing. But that's just my opinion.
If you are obligated to permit us, since we filed on time, you're obligated to permit us to participate as what you call participating witnesses and ask questions. You're obligated to do that because of condition number or standard number 5. We're certainly part of the community. There's no question about that. And you should go ahead and do that. If not, we're going to take an objection or exception to your decision. And I don't think that would be good in terms of getting this to finality in an efficient way.
Thank you for that. Heather, do you have thoughts on this, Ms. Baker? Excuse me.
Yes, that is not a correct legal standard. Those standards do not have anything to do with standing, and I think your analysis is correct. This application is with the others that are not in the realm of those you've allowed to participate as witnesses, which, by the way, is completely up to the council.
Yes.
As to who you allowed to participate as a witness.
Okay. With that said from Ms. Baker, does anyone have a motion to be made that we do not allow Mr. Salveson, Ms. Bianchi to participate as witnesses or as parties with standing, based on our past decisions for folks that have made similar applications from 208 Swiss Lane, which is pretty much right on the way to this guy's house, on 53 Honeybee Bend, which is just across the hill in Trillium. Are there any other questions for Mr. Salveson or Ms. Bianchi from members of the council?
Make a motion to remove Mr. Salveson from being a witness or party withstanding.
Okay, that motion has been made by Mr. Lutzen. Do I have a second? Okay, all in favor?
Aye.
Aye. Seems like we had a unanimous, but Glenn, were you in favor of that? That was a unanimous vote. Thank you very much for participating, Mr. Salveson.
Mr. Chairman, can I make one point of clarification just for anybody looking in on this record relating to this individual?
Yes, please go ahead, sir.
This doesn't prevent some party withstanding, if they felt like this individual had competent, substantial material evidence related to the standards in question, doesn't prevent any party withstanding to call him as a witness. He would then have to do those things with probative evidence. So just to let this individual know, so he doesn't feel like he has no avenue, he could go to a party withstanding and they could call.
Thank you very much for that, sir. Okay, moving on to Mr. William H. Chauffeur / Silverleaf Capital LLC, who is claiming his home is at 415 Monte Vista Road. William, are you there? Is he on the Zoom
Yes,
call?
I just signed in. I just did sign in.
Okay, so it says here in your application that you did not receive a letter that, well, I think you might have filled out this blank wrong, but you purchased your home at this address October 26th, and you're alleging, it doesn't see that you are alleging any special damages. Are you seeking to participate as a party withstanding or as a witness?
I would probably say more as a witness. We just recently purchased the home and it is adjacent to the property in discussion, and wanted to understand what the development is, what is going on with the development.
Okay, thank you very much, sir. It's my instinct that he like reaches that bar of participating as a witness Counselors, do you have any comments? Additional? No.
Mr. Chairman, I'd like to make a motion that we allow William Schaeffler as a witness in this proceeding.
Okay, so Mr. Dews has made a motion that we allow Mr. Chauffeur to.
One point of clarification, just for the record, if that could, I think his application is both his name and for Silverleaf Capital LLC. I think just to make sure that we're resolving both names that are on the application for clarity in the record.
Thank you very much, Mr. Knorr. If you could amend your motion, Bob, that to include Silverleaf Capital.
So moved to include Silverleaf Capital LLC.
Okay, and then do I have a second? Second. All in favor?
Aye.
Okay, thank you very much. Moving on to Lisa and Glenn Ullman of 60 Watch Hill Lane. Are Lisa and Glenn, the Ullmans, on our call today?
Yes.
Okay. It says here in your application that you did not receive a letter from the Jackson County Park, and maybe you mischecked this box that you had an ownership interest in the property. You're saying that you will suffer special damages and that your damages are distinct from the community at large.
This was in, we're part of the Johannesson Association.
Okay.
So we're being represented by the attorney.
Okay, so you're agreeing to be part of their agreement to participate as witnesses and be covered under that Johannesson Property Owners Association.
Yes, exactly.
Okay, and then previously for the Morans, we made a motion that the Ullmans would be included as a witness. So if I could have a motion from someone on the council that the Ullmans will be included as a witness, I could have that motion now, please. Okay, so Mr. Bond has made that motion. Do I have a second?
Second that.
Seconded. All in favor? All right, and that was seconded by Mr. Dews. All right, moving on to Jonathan A. Zachary of 106 Gonaceto Road. And this is the first one that I
Did we
don't
skip
have
over
the
Mr.
application.
Wood?
We skipped one over.
Robert Wood would be the next person in line, I believe.
Oh, okay, so just a second, John, we'll just try to stay in order. I missed this one. All right, so let's jump back to, I do have Mr. Wood's application next on my pile, and I was messy with my checks here. So let's go back to Mr. Wood. Is Mr. Wood participating on the call today?
Mr. Wood is here, but he had to run to another meeting. So if you could come back to him, that would be great.
Who am I speaking to?
This is his secretary, Ellen Albright.
Okay.
He just had to step out for a moment. I can go get him if you want to wait for just a minute. He just had to meet with somebody else.
If you could get him real quick, that'd be helpful.
Sure. Bear with me just a moment.
Thank you.
Do we have to hear testimony on that? Or
Well,
from his application?
I just want to give him a chance to prove, but I think we can start to discuss that. No, he did not receive a letter from Jackson County. He has not checked that he will suffer special damages. Do we have his property highlighted up on Big Sheep Cliff Mountain? So it's quite a distance from the thing. He's saying that the damages he will suffer are not distinct. Traffic congestion, pollution, adverse strain on infrastructure, water, sewer, garbage. That he's part of the Big Sheep Cliff POA. We'll give him just a minute to see if we can get back to him. Otherwise, it seems like to me that he is more similar to those folks that we have not allowed to participate as a witness or as a party. So we'll just give him another 60 seconds and I know Mr. Wood is not present, but I'll just ask you
Hello,
to.
I'm here now. Thank you for waiting.
Hello, Mr. Wood. How are you? Are you there? Can we hear him?
Yes, I'm here. Can you hear me?
Okay. We were just going over your application, and it seems like your application is more similar to those folk that we have not allowed to participate as either a party to the action or as a witness. It seems even in your application, you've said that your damages are not distinct from those damage to the public at large. Do you have any other comments or arguments that would sway me or the rest of the council?
No, having heard all the proceedings thus far and the ways you've been dividing the groups into things, I wouldn't have anything more than what others have had, and would love to still be a witness, but I can't see from what we've talked about that I would have standing in those particular legal ways.
All right. Thank you very much, Mr. Wood. Based on what we've done so far, I'd ask for and thank you for participating, Mr. Wood. I'd ask for a motion from a member of the council to deny Mr. Wood as a party with standing and as a witness.
Mr. Chairman, I move that we not allow Robert B. Wood as a witness or a member of standing in this.
All right, Mr. Dews has made that the motion, excuse me. Do I have a second?
Second.
All right, Mark has seconded that motion. All in favor?
Aye.
All right. Okay, that's unanimous. All right, moving now back to John, and I appreciate you having patience with us. Mr. John A. Zachary of 106 Gonacita Road. It says here in your application that you did receive an email, even though it went to a letter, even though it went to the incorrect address, you have received it, that you have an ownership interest, not in this property.
No, in this property.
In an adjoining property. And that you're saying that you will just suffer distinct damages from the public at large. Construction will greatly restrict access to your residence. Tremendous increase in traffic from construction. And occupancy will restrict access to all community businesses. That's under the not distinct thing, but you're saying that the damages you would suffer are what? Go ahead and tell me what damages.
Yeah, let me restate that. The family property there that's circled in blue, there's a house there right under the number where I'm living. That house and the house below and the property below and left a bit are fed by springs that originate up toward the top of the map toward the left. That's the only water we get, and it's downhill from the development, which is just to the north, the proposed development. And my concern is for our water supply. That is our only water. The rest of those things apply as well. The access, especially during to the property, especially during construction. Noise, light, anything that would accompany a development of that size. Right now, where I'm living, it's not within sight of any other house. We get darkness at night, and we're kind of used to that. And we'd like to continue.
All right. Are there any questions from the parties that are represented by counsel or other parties that have been admitted as parties with standing of Mr. Jackery? Comments or questions at this point?
Mr. Chairman, I don't think all the witness has provided the evidence to show standing.
I think it's more in line of the folks in the subdivision out in that neck of the woods to participate as a witness.
Well, the property adjoins the proposed development on at least two sides. And And our property is downhill from the development. I mean, directly below it. The cell tower's in the top left corner. And it's all uphill to the cell tower, which is near the apex of the ridge.
Well, it seems to me that you, with having that adjoining border, you have a different claim than those members of the Gonaceto Property Owners Association. Mr. Noor, do you have any questions for Mr. Zachary?
I don't have any questions. I think just as Ms. Baker's pointed out, consistency on how things have been treated in the past may be a consideration you want to take into account.
Thank you very much. It seems to me that what Mr. Noor pointed back to is that is that you have a claim based on like consistency of who we've allowed with people with standing. You haven't alleged a lot of like really serious special damages.
Well, there would be if our water is polluted.
That is actually a pretty good point. All right, based on that, based on his point that his property is on a spring and it's adjoining on two sides, I say that he meets that higher criteria of parties that we've admitted with standing. Could I have a member of a council, if they choose to do so, make a motion to allow Mr. Zachary as a party with standing?
I move to allow Jonathan Zachary to participate as a person with standing.
Okay.
Second that.
And that is seconded by Mr. Dews. All in favor?
Aye.
Aye, that's unanimous. Thank you, John. All right, moving on to the application from Mark and Judy Zachary. Ms. Zachary, it says here that you did receive a letter from the Jackson County Planning Department that you'll suffer special damages because you're a wildlife preserve, and I'm having trouble reading this writing on the next line. Something clear out 30 acres will destroy the deer and turkey habitat. Now, are you referring to the property where you live, or your interest in that same property that where Mr. Zachary lives? Ma'am.
Mark and I own adjoining property to the family property.
Okay. And that adjoins the boundaries of the proposed project?
That's correct.
Okay. So you're alleging your special damages will be this loss of the natural habitat and also some non-distinct damages, traffic congestion, and water usage. Is your home on a well or a spring, ma'am?
We're on a spring.
Okay. But the property where your home is quite near to this project, but it doesn't adjoin it? But your vacant land adjoins it?
I can't hear you.
I'm sorry. Your property where you live does not adjoin the project, but it's quite close, but your vacant land that you own does adjoin the project. Is that your understanding?
Where our house is does not, I don't think it does.
Do you know if the spring is on the vacant land or on the property where the house
The
is?
spring is on our property.
Okay, but obviously we know.
Actually, it's on his property.
Our
spring is actually on his property.
Okay, so it is, you draw water from that same property.
Yes, we do.
That adjoins on two sides.
Yes, we do.
All right. So you're worried that besides the loss of this wildlife habitat, that it could affect your drinking water supply?
That is correct.
Okay. Do you have any other points?
I'm
or
concerned
arguments for your
about,
standing?
I'm concerned about all the traffic and the noise and the fact that it doesn't fit our community at all. Yes, I have lots of concerns.
Okay. But any specific arguments for why you should have standing, other than the water, noise, traffic, and loss of habitat?
That's all.
Okay. Mr. Justice, do you have any different objections?
She raises habitat. Is she talking about the property to be developed is the habitat?
I think she's talking about the loss of habitat near her property, which she is saying that she keeps as a wildlife preserve. That's my understanding. Is that what you're saying?
Those are probably Mark's words. Together we have 30 acres, and there are a lot of deer and bears.
This
and
is the family properties you own.
Correct.
Okay. And that it's just going to substantially change it from going from a wooded property adjoining your woods to a developed urban property.
That's correct.
Okay.
We're also concerned about security around, because our property basically is on the south side and the west side. I think that's correct. The whole boundary of our property is surrounded by this new development.
Any other questions, Mr. Justice? No. John, any questions?
I don't have any questions for Ms. Zachary.
Okay. It seems like she's right on the line here because she's a little further, but it seems like with having her water come from a spring on this adjoining property, that her claim is more similar to these higher level people that we've allowed to participate as parties with standing, because of her water coming from a spring on the property that where we've already allowed Mr. Zachary to participate as a party with standing. So it would be my inclination to let Mark and Judy Zachary participate as parties with standing. Do I have a member of the council that would make that motion?
Motion to allow Mark and Judy Zachary to be a party with standing.
Okay, so Mark has made that motion. Do I have a second? Dave is seconding that motion. Mr. Bond. So all in favor?
Aye.
Aye. It's a unanimously approved. Thank you, Ms. Zachary. All right, moving on. I think that brings to an end the list of people that applied for standing prior to our past hearing. Now there has been 3 additional applications received after the deadline. Before we hear these, Heather, would you like to make any comments about these?
I would. At any time throughout the process, even in the middle of the substantive part of the hearing, it could come to light that a party may have standing and they can apply at that time. And it's up to you as a council to hear that. So anybody that contacted us since the last hearing and had a question or wanted to fill out an application, we encourage them to fill out an application. I would recommend that you go ahead and hear these in the same fashion as you've heard the others. And just keeping in mind, it could come up again even before the 25th or even during that hearing, and it's something you may have to stop and address at that time. Of course, the deadline of when they applied is something you can consider as part of their application, but I would recommend that you consider these as you have the others.
Okay, thank you very much, Ms. Baker. Do the attorneys for present, do they have any concerns with us hearing these 3 further applications in that fashion, in the same fashion?
The timeliness of their requests, no, I do not have any objections to consider them.
No objections from us.
Okay. Moving on then, let's hear from a Mr. Les Alderman of 13 Beaver Court, Sapphire, North Carolina. Is this Les? Are you there? Are you here today with us? So he's saying that he did not receive a letter. He is not suffering special damages. His property is way over in Sapphire. So I would say that he fits in this category of folk that we have not been allowing to participate as witnesses or as parties with standing. So if the council has no problem with that, if a member of the council would make that motion at this time to not allow him to participate as a party with standing or as a witness.
Mr. Chairman, I'd like to make a motion that Leslie Alderman Jr. not participate as a witness or a member in standing.
Okay, Mr. Dews has made that motion. Do I have a second? That's been seconded by Mr. Ubertino. All in favor?
Aye.
Okay, that's unanimous. Moving on to a Mr. Patrick Hurley of 451 Highway 107 South. Mr. Hurley is saying that he did receive a letter from the Jackson County Planning Department, and the rest of the application is not filled out. Is Mr. Hurley on the Zoom call?
Yes, I am.
Okay. Now,
and I apologize for that application being a little incomplete. I was speaking with the lady at the planning, who I think it was Allison, who had sent it out, and I just wasn't 100% clear on what should be included. I was informed that the biggest thing was to submit it with my signature or whatnot, but I do own an adjacent parcel to the proposed development.
okay. And the property that you own, I'm a little unfamiliar. Is it vacant land at this time?
It's not. There's a house on it. We've been renovating. We purchased the property, I believe, in October of 19. So unfortunately ran into several things, not the least of which was COVID that really delayed things. But yeah, we're nearing completion of our renovation.
Okay. And so that's, you're north of one property north of Old Cashiers Village, just to be clear.
Yes, I believe so. Yep.
Okay. All right. Are you seeking to participate as a party with standing, or are you seeking to participate as a witness?
As a party with standing.
Okay. And since your application is somewhat incomplete, I will ask you what special damages that are distinct from the community at large that you are alleging that you will suffer.
Specifically, being directly next to it, it's going to be some of the things that have been brought up with the drinking water, the well availability, direct consumption there at the property. Also, direct noise, since again with the building going so close to mine, it's not just a drive-by thing. I will be there trying to enjoy my home, and so that construction is going to have a large impact. And also to the point that somebody else just brought up with wildlife. Part of what I like about my property is that it was, 2 acres with a large chunk above it. And I do have wildlife there that obviously will be driven out, fairly directly.
Okay, thank you very much, Mr. Hurley. Before I throw this to council, it seems that based on the standard we've set so far, him being a joiner and him having concerns about his drinking water, does your water come from a well, sir?
Yes, sir.
Okay. Are there any new comments? It seems like these are the folk that he's at the level of the people we've been letting in with standing. Mr. Justice, do you have any thoughts on that?
Well, nothing new to the objections that I've previously been making, so nothing.
Okay, so the previous objections.
Nothing to add, Mr. Chair.
Okay, council, it seems like as an adjoiner getting his water from a well, meets the standard of parties that we've been allowing as parties with standing. Can I have a motion to approve him as a party with standing?
Mr. Chairman, I move that we allow Patrick Hurley as a member of standing in this proceeding.
Okay, so Mr. Dews has made that motion to allow Mr. Hurley as a party with standing. Do I have a second? Glenn has seconded that. All in favor?
Aye.
All right. All right.
Thank you.
Lastly, we come to the Cashiers Canoe Club Development LLC. Turner Insco, and Michael Rip. Mr. Insco and Mr. Rip, are you on the call, on the Zoom?
We are.
Yes, we are.
We are.
Okay.
Yep.
So
All
it
right.
says here in your application that you did not receive a letter from the Jackson County planning, I'm losing my mind here, from the what are you guys? Planning department, thank you all. But that you will suffer special damages and that you will suffer damages that are distinct from the public. And you have attached a document here. Would you like to present this, Mr. Insco or Mr. Rip, your allegations of special damages?
Sure. So in the planning department's defense, the notification would have been late anyway, but the reason we're coming today is that there's been a tract of land that has been put under contract along Valley Road. And so that is contiguous to the lake. It abuts the lake, Cashiers Lake. And so our interest is in, as the adjoining property owner and the member of the Lake Association and ultimately Cashiers Lake. So our understanding is that this property was put under contract to assist in their stormwater management plan. And our civil engineer has spoken with the applicant civil engineer yesterday to confirm that there are considerations to utilize Cashiers Lake for stormwater management. So we have a very real interest in how the stormwater is managed, given the real expenses we've historically incurred, such as an $800,000 rehabilitation to the dam in 2011. And in addition, we're currently in the process of obtaining the proper permits and authorization to conduct really much needed lake dredging and maintenance from previous upstream development that has deposited silt into this lake to the point that water flow has been restricted, as many of us know from experiences going down Frank Allen Road. So we have very real interest in understanding how the stormwater will impact Cashiers Lake and how we can jointly manage the future health and maintenance of this significant water resource. We've had great communications with the applicant in the past and truly expect that to continue in the future. And I'm confident that our two engineering teams can work together, and we'll be prepared with our experts to present evidence as necessary at the actual hearing, if necessary, for a proper solution. But we just want to make sure we're entering into a conversation around this topic, because without that stormwater being properly managed, it obviously puts the health of the lake in peril, and the maintenance and the past investment that we've put into maintaining that lake in question.
Okay. Mr. Justice, is it true that you have put a property under contract that adjoins the Cashiers Canoe Club development property and Cashiers Lake, and that property that's under contract should be considered as part of this application?
Mr. Chair, before the applicant responds, we've been a little bit casual with oaths so far today, and I figure if this is going to be a factual dispute between the applicant for standing and then the developer, that maybe oaths need to be administered for reliability purposes in the record.
Heather, your thoughts on that? Just 1 second.
Oaths.
If
your client is going to testify as to the factual existence of a contract or not, I'm wondering if we should have those administered.
Well, what are your thoughts on answering this question first?
Well, first off, we haven't. So the answer is no. And we've had.
Would the answer? Give me a little bit more than no.
There's no property under contract.
Okay.
One. There is no property other than what is before you in the development application. So,
if that's the case,
just a second.
If that's the case, then
just a second. Go ahead. Please finish.
To address John's question, we actually haven't sworn in anybody today.
That's
providing
right.
Information, and we've just sort of let it go. So, to expedite, the answer is no. The gentleman is I'm not sure what the conversation was, other than he is not correct. There is no property under contract. There is no other property as part of this development plan.
Okay, go ahead, Mr. Knorr.
Well, this is the first situation where I think we've had a factual dispute,
Understood.
And so I think you all dispute the general allegations that previous applicants have had for standing.
Okay,
but-
so let me just hear from Heather real quick on this. Ms. Baker?
With regard to the oath, I don't think Mr. Justice needs to take an oath. So unless he's going to have his client testify to this, I don't think that's an area where we need to go or we need to consider it. I do think potentially that, that this applicant for standing has given you enough, whether or not this is correct, to make a decision to be able to move forward with standing. And this may be something that's vetted further in the hearing. And if so, they will be under oath at that time, and those questions can be asked and more information can be obtained. So I think at this point, to see if you feel there's enough at this point to allow them to have standing, or at least to participate as a witness, and then this may be developed further if there are questions as in this regard in the hearing, substantive hearing itself.
My point was only made because I saw the microphone in Mr. McCauley's hand, so I thought he might be giving the answer to that versus Mr. Justice.
Understood, Mr. Knorr. Mr. Justice, in your negotiations with Mr. Knorr, you allowed for the Chattooga River Conservancy to be admitted as a party with standing?
We had stipulated to that to expedite things, correct?
Okay, and so most of this, it has to do with Cashiers Lake, which this applicant to participate as a party with standing owns. So it would seem like his interest would be quite similar to theirs. I mean,
sure. I don't disagree with that. I'm not agreeing to the party having standing, but I agree with your characterization of the similarity between the conservation folks and
okay. So, but you're saying right now there is no property presently by the applicant under contract on adjoining Cashiers Lake, and it shouldn't be considered as part of this application, because if we have this other gentleman saying that his civil engineer is talking to your civil engineer, and it's a fact, we do have a disagreement.
Correct. There
is a disagreement.
There is a disagreement that property is under contract. There is a disagreement that this is something that this council should consider. What I'm agreeing with is the characterization, Mr. Chairman, that you just made, that the conservation folks we stipulated to. And so, although I'm not agreeing to standing for the Cashiers Lake folks, there is some similarities there.
Okay. Mr. Knorr, before I go back to Mr. Insco and Mr. Rip, do you have any further thoughts? Since your client is the Chattooga River Conservancy?
No additional thoughts. We agree with your characterization of the similarity.
Okay. Heather, do you have any thoughts before I talk to Mr. Insco?
No, I think we've said everything.
Okay. Mr. Insco, Mr. Rip, do you have any further thoughts on this? Setting aside the disagreement about whether there is a property under contract adjoining your lake?
I am obviously misinformed, confused, and I'm sure we'll talk with the applicant after to better understand it. I would just ask that consideration be given before the meeting on the 25th if something comes to light, and we'll happily come back at that point. Again, we're just trying to address any development use that has an impact upon Cashiers Lake, and we put so much time and effort into that, and it's to make sure that we continue to manage that water resource as the member of the Lake Association. So that's the ultimate intent, not to be obstructionist, but it's to better understand what's going on the development. So again, if it's not for property that abuts us, then we can hold until the 25th, and I'll try to get some clarity around what's obviously a grand misunderstanding.
Did we already have someone we were waiting to decide if they had standing for at the beginning of the meeting.
We
So
do, Mr.
what I'd
Chair.
say at this time is, understanding that it's been stated, there's a very similar claim between the owner of the lake and the Chattooga River. Let's get to the bottom of these facts, and we'll just hear your application for standing. Who's the other one that we're waiting on? Anita Kramer. So we'll hear you right after Anita Kramer at the beginning of our proceedings on the 25th. And we'll get to the bottom of the standing at that time. Are you agreeable to that, Mr. Insco?
Yes, thank you.
Okay. You agreeable to that, Mr. Justice? Okay, seems like everyone's on board. And so we'll handle that. With that being said, that has brought us to the end of our list of parties that have made applications for standing. And it seems that it was previously agreed by the parties that we would continue and pick this up on the 25th. Mr. Knorr, Mr. Justice, you agree to that? Okay, and so our regularly scheduled meeting, members of the council, is for one of our evening meetings, but we would have to change that to a 9 a.m. meeting. Is everybody able to do their best to make it work with that? Okay, so let's change our meeting to that and give the relevant notices. And with that being said, do I have to make a motion to continue this hearing to 9 a.m. on the 25th, Heather?
Yes, you'll recess this hearing until I assume 9 a.m. I think that's when we have the facility reserved on the 25th. Mr. Knorr, I believe, has a question.
Just one question before you adjourn or move to continue. Would we mind, just for clarity in the record, that we go through the list of the names where everyone was found to have standing, just to summarize the hearing at the end here, just so we're all on the same page and everyone who's tuning in can hear that as well? And I'm happy to read those names off, and then if I read them wrong, correct me. Mr. Chair, does that work for you?
Okay.
Okay.
Go ahead, Mr. Knorr.
The names I have that the council approved for standing are Nicole Heiler in the Chattooga Conservancy, Sarah Jennings, Stephen Johannesson, Juliana Kaufman, Brent Millis, Laura Moser, Jonathan A. Zachary, Mark and Judy Zachary, Jeannie Mingy, Yvonne Johnson, Patrick Hurley. Those are the names that I have.
That's what I have as well. Is that what you have, Mr. Justice?
I believe so.
All right, and anyone from planning disagree with that? Do we have a separate list of who has been approved to participate as witnesses? I did not keep track of that.
I have that as well.
Okay, if you would, that would be helpful, Mr. Knorr, to read that list.
Okay. That list is Deborah and Stephen Clark. Forget.
Oh, yeah, the Gonisita Property Owners Association.
Yep. Gonisita Property Owners Association. Thank you. Deborah and Stephen Clark. I have Sean Cornyn approved to participate, or do you have that as a?
He was denied.
Forgive me on that one. Then I have William Wallet and Susan Graham.
Mary Ellis is approved to participate as a witness. William Wallet and Susan Graham, they were part of the Gonisita Property Owners Association, I believe.
And I think that's under the understanding of the participation, but not, yeah.
Yeah.
So it was Mary Ellis, William Wallet, and Susan Graham. I have Susan Hamilton.
Yes.
I have Connie Hawkins and Kevin Hawkins.
Yes.
I then have Jamie and Mark Moran.
Yes.
I then have Jamie and Patricia Nardi.
Yes.
And then have Kelly Ryan.
Yes.
And then I have William Schufler and Silverleaf Silverleaf Capital LLC.
Yep.
Then I have Lisa Glenn Ullman.
Yes.
And that is the last on my list.
I think that matches my recollection. Anyone have any problem with that, Mr. Justice? Planning?
That's what we have as well.
Okay. All right. So can I just call like a recess to the 25th, or do I need a motion?
Do you have a motion?
Yeah, if someone would make a motion for us to recess until January 25th at 9 a.m., meeting back here at this time. Mr. Bond has made that motion. Do I have a second?
Second.
Okay, I'll get Robin on that one as the second. All in favor? Aye. Thank you very much, everyone.